Calling this meeting in order. Today's meeting is pursuant to the order of reference Thursday, March 31st. Hold on a second here. It's meeting number 18 of the House of Commons Standing Order on Justice and Human Rights, pursuant to order of reference Thursday, March 31st. The meeting is coming to study Bill C-5, an act to amend the Criminal Code and the Controlled Drugs and Substances Act. Today's meeting is taking place in hybrid format pursuant to the House Order of November 25th, 2021. Members are attending in person in the room and remotely using the Zoom application. The proceedings will be made available via the House of Commons website. I think I have to give any instructions to anybody outside the room. Mr. Garrison is a pro, and wishing him well and a healthy recovery from his cold. I'd like to welcome our two witnesses today. We have Matthew Taylor, General Counsel and Director of the Criminal Law Policy Section, and we have Andrew DeMano, Counsel, Criminal Law Policy Section. So I think they'll be both here to answer any questions any of the members have as we do clause by clause. I'd like to start with the clause by clause consideration of C5. Save this. I'd like to provide the members with some instructions and a few comments on how the committee will proceed with the clause by clause consideration of Bill C5. As the name indicates, this is an examine of all the clauses in the order in which they appear in the bill. I will call each clause successively, and each clause is subject to a debate and a vote. If there are amendments to the clause in question, I will recognize the member proposing it, who may explain it. The amendment will then be open for debate. When no further members wish to intervene, the amendment will be voted on. Amendments will be considered in the order by which they appear in the bill or in the package each member received from the clerk. Members should note that amendments must be submitted in writing to the clerk of the committee. The chair will go slowly and allow all members to follow the proceedings properly. Amendments have been given an alphanumeric number in the top right corner to indicate which party submitted them. There's no need for a seconder to move on an amendment. Once moved, you will need unanimous consent to withdraw it. During debate on an amendment, members are permitted to move sub-amendments. These sub-amendments must be submitted in writing. They do not require the approval of the mover of the amendment. Only one sub-amendment may be considered at a time, and that sub-amendment cannot be amended. When a sub-amendment is moved to an amendment, it is voted on first. Then another sub-amendment may be moved, or the committee may consider the main amendment and vote on it. Once every clause has been voted on, the committee will vote on the title and the bill itself, and an order to reprint the bill may be required if amendments are adopted, so that the House has a proper copy for use at report stage. Finally, the committee will have to order the chair to report the bill to the House. That report contain only the text of any adopted amendments, as well as an indication of the deleted clauses. Any questions? We all good to start? Okay, so I will begin. The chair shall calls clause 1. Shall clause 1 carry? Okay. Yes, Mr. Moore?
Just some of these clauses are similar, but I'm just wondering if the department can give us a brief description of the effect of if we choose as a committee to adopt clause 1.
So subsection 84.5 of the Criminal Code directs that a conviction for certain offenses in an earlier offense for the purpose of triggering increased mandatory minimum penalties applicable to second and subsequent offenses for the offenses of section 85, using a firearm or imitation firearm in the commission of an offense, section 95, possession of a prohibited or restricted firearm with ammunition, section 99, weapons trafficking, section 100 for the purposes of weapons possession for the purposes of weapons trafficking, and section 103 importing or exporting knowing it's unauthorized. Clause 1 would remove the references to subsections 85.3 and 95.2 from the subsections 84.5 because these subsections will no longer have escalating MMPs. So Clause 1 is a consequential amendment to Clauses 2 and 4 of the bill.
If I could just add, Mr. Chair, for your consideration, because it is consequential to other clauses in the bill, the decision on those other clauses would have an impact on this clause as well. So, for example, if you decide to pass some of the clauses that propose to repeal MMPs, then you would need to make this consequential amendment. If you choose to retain those MMPs, you would have to revisit whether this amendment is necessary as well.
Yes, Mr. Moore.
To just flesh this out a little bit because, frankly, in the context of our committee meetings that we've had, and we haven't had a ton of them, I think we had 8 where we heard witnesses, or 7 where we heard witnesses, plus today's meeting is our 8th. Is just for clarification, when we talk about the mandatory minimum penalties in these sections, this is on someone who's already been convicted of the same offense, and this is so now they've been convicted twice of, for example, weapons trafficking or possession for the purpose of weapons trafficking, because, a lot of the discussion that happened and witness testimony at committee was couched in the terms that this was, someone got caught up in an unfortunate incident, someone had a few drinks and shot the side of a barn. These were for this section, are we talking about for 85, 95, 99, 100, and 103, we're talking about someone who this is their second offense. So is there a minimum on their first offense? And then what is do any of these, says second and subsequent. I guess I'm familiar a bit when we, in a previous government, when there was a mandatory minimum penalty of 4 years for certain gun crimes. And because of the issue of recidivism, which is basically the same person committing the same types of crimes over and over, we brought in a change to the law that meant on your subsequent offense, it would be 5 years, and then after that, 7. I think that's where it kind of landed. I think originally it was 4, 7, 10, or something like that, but eventually it landed at 4, 5, and 7, I think. But I just want the committee to be 100% clear, because this, I don't think it ever came up in our witness testimony. Are we only talking in this clause on someone who's already been convicted of a prior offense in the same section of the criminal code?
Yeah, thank you for the question. Yeah, this is a clause that really provides guidance to the courts as to when they're considering whether to impose a higher MMP because the conviction is a second or subsequent conviction. The offenses that are listed in the subparagraphs, paragraphs A, B, and C, constitute a first offense for the purposes of determining whether the higher MMP would trigger. So currently, the five offenses in subsection 5. So Section 85 is use of a firearm in the commission of an offense. 95 is possession of a prohibited or restricted firearm. 99, 100, and 103 are trafficking and smuggling offenses. So if an individual has been convicted of one of those offenses, the court would look to this provision. If they have a previous conviction it's a broader list, 85, 95, 96, 98. If they have a previous conviction for those offenses, there would be a higher MMP imposed by virtue of this provision.
And I should be asking these through you, Chair, but I just have I want to flesh out a couple things here. So through you, Chair. So the list of offenses that are subsequent is broader than the list of offenses that predicate, the triggering of the mandatory minimum. So on those offenses, that the first offense, is there a mandatory minimum attached to each and every one of those first offenses? I think there is on some of them, but is there a mandatory minimum penalty at first offense for weapons trafficking, for possession for the purpose of weapons trafficking?
Yes, well, 85 has a mandatory minimum.
Through them then, if you have it in front of you,
Sure,
could you?
sure. So Section 85 does have mandatory minimum penalties. Section 95,
So, and the mandatory minimum on Section 85 at first instance is 1 year?
and subsequent is 3 years. Section 95 did have mandatory minimum penalties, but they were found unconstitutional
Struck down.
by the Supreme Court in Noor. Section 99 has mandatory minimum penalties of 3 and 5 years, I believe, for first and second or subsequent offenses for firearms, and a 1-year MMP for other things like prohibited weapons or restricted weapons. Section 100, the same. Section 100 is possession for the purposes of trafficking, so it follows the same sentencing structure as Section 99, so 3 and 5 years for firearms, and 1 year for prohibited weapons or restricted weapons. And then 103 is the smuggling offense, firearm smuggling, 3 and 5 year again, with a 1 year for things other than firearms.
Okay. And this is, I mean, this legislation touches on a lot of different offenses. They're different offenses, different impacts. I would argue different levels of seriousness. They're all criminal code offenses, but some of them, no doubt, we as a committee may feel are more serious than others. Of those 5 that you've been speaking about, 85, 95, 99, 100, 103, is it possession of a prohibited or restricted firearm with ammunition? I remember this case. Is that the only one of the 5 that has been challenged and was found, the mandatory minimum was found unconstitutional? And I guess follow-up, could you just walk us through why this discussion isn't moot? Because while the mandatory minimum in this narrow case was struck down, it remains a trigger for that escalation for subsequent offenses. Is that why this conversation isn't moot, since the court in that case struck it down? While we know, I guess the government's own backgrounder that came out suggested, I think it was 48% of cases where mandatory minimums had been struck down, but meaning that in 52% of cases they had been upheld. And we acknowledge there's cases where they've been struck down. There are cases where they've been considered and upheld. My question is, if you could walk us through the effect of that one offense being struck down and why it still matters in the context of this clause.
Yeah, so in the newer decision in the Supreme Court struck down the 2 MMPs for Section 95, so there are no MMPs currently. To go back to an earlier question that was posed, there is jurisprudence, constitutional jurisprudence on the other offenses listed. Varying results. In some cases, provisions have been upheld by the courts. In other cases, they've been found unconstitutional. So in terms of Section 85, there have been appellate decisions where the MMPs have been upheld. I should caution, though, that those decisions occurred before the Supreme Court's decision in Noor and its subsequent decision in Lloyd, which has adjusted the interpretation of Section 12 and constitutional jurisprudence. Section 99, the weapons trafficking, there have been cases where it has been struck unconstitutional. As with Section 100, Quebec Court of Appeal in 2019 and 103 Quebec Court of Appeal in 2019. Now, none of those cases went to the Supreme Court of Canada, but there is jurisprudence as described.
Okay. Well, thank you for answering all those questions really thoroughly. Mr. Chair, on this, and I'm going to ask the committee, all of us as members, we have an opportunity to vote on this clause. I look at these offenses, and we are talking about recidivist in these, with these offenses. No one is arguing that we shouldn't do everything our level best at the federal level with our provincial counterparts at the municipal level. No one is arguing that we shouldn't do everything we can to help people and help them reintegrate into the community. We have to recognize that at some point people are going to be back in the community, and we should do our best to reintegrate them. But when I look at this list of offenses, it's like they're pulled from the headlines of what we're dealing with right now in this country. Police chiefs, and we had witnesses at the committee who spoke about their own jurisdictions. Some of them were major municipalities. Some of them were the most rural places imaginable. Some of them were urban, suburban, First Nations policing. We heard from a variety of witnesses in policing, and the evidence that they gave us is that the types of firearms they're seeing, both in urban and rural settings, are not, John Q. duck hunter, farmers, sport shooters. It is weapons and firearms that have come in from the U.S. largely. They've been trafficked in. I see weapons trafficking at one of these offenses. They are largely prohibited weapons or restricted weapons. The people using them are not licensed. They're unlicensed. So what we have in these offenses, and I'm speaking specifically of the offenses in this clause, we're dealing with people who at no point have tried to comply with Canada's laws. As all of us in our ridings have people that have complied, they're law-abiding firearms owners. They have, first, they have a license. They're licensed owners. Second, they've gone through proper channels. They didn't necessarily buy a handgun out of the trunk of someone's car. They went to a dealership and purchased a firearm legally. And the testimony that we've heard over and over again at committee is that those are not the individuals that are creating the problem. Even while we were in committee, we heard ripped from the headlines, stories of people using drones to take a bag of handguns from the U.S. and bring it across into Canada, presumably to be picked up by the criminal element here and distributed and sold and at some point very possibly used in a crime against an innocent Canadian. So I want to... we can have a debate about the role for mandatory prison sentences, and we've done that. We've gone around. We've heard a lot of different witnesses, and we've heard from members of the committee. But I want us to look really careful at this particular clause, because to me, it's dealing with scenarios right now that Canadians are calling out for action. We're seeing it in New Brunswick. We're seeing it in Ontario. We're seeing it in Quebec. We're seeing it in every province that they're saying we need help. Rural crime's an issue. Urban crime's an issue. And we just saw Mitch Marner, for Pete's sake, of the Maple Leafs was just robbed. I don't know all the details, but from what I read, the armed assailants, I will guarantee you the people that robbed him didn't drive away in a pickup truck wearing fluorescent orange with their shotgun that they use for duck hunting. This is a criminal element. I'll also guarantee you, probably it wasn't their first offense. These are individuals who knew exactly what they were doing, and they carjacked Mitch Marner the same way they've probably carjacked other people. And yes, eventually someone's going to get killed in the process. It's that kind of recidivism. It's that kind of wanton disregard for other Canadians, for innocent individuals. That's the reason why these laws are in here. We have to start from the premise that we have a criminal code that we as Parliament have said these are things that are bad. These are things that we don't want to happen in society, and there's a reason that some offenses are dealt with summarily. Some offenses are seen as less serious. Some offenses in Canada, you receive a monetary penalty, a fine. Like if you're speeding in New Brunswick, the fine might be $168. But if you have possession for the purpose of weapons trafficking, if you have importing and exporting knowing it's unauthorized, if you're involved in weapons trafficking, using a firearm in the commission of an offense, these are the offenses that Canadians want us to deal with. And so I'll leave it at that, Mr. Chair. I just want us to really take a sober look at these offenses before we vote on them. And I do thank you again, Mr. Taylor, for very thorough responses to all those questions.
Thank you, Mr. Moore. I think Mr. Nansingari, no?
No, just
No. If seeing no other debate, recorded vote, I assume. All those in favor, shall clause 1 carry? Recorded vote?
Please.
Madame de Saint-Gary. Madame Brière.
I thought I would have convinced you.
Oui.
Mrs. Dillon. Mrs. Diab.
Oui.
Mr. Nagby. Mr. Brock. No. Mr. Cooper.
No.
Mr. Moore. No. Morrison.
No.
Monsieur Fortin.
Oui.
Mr. Garrison.
Mr. Clerk, when I point out you're not using the microphone when you're doing this, so it's impossible for me to
Sorry, I
hear.
was too sorry about that. Mr. Garrison.
Yes.
Seven yeas, 5 nays. Motion's carried, clause 1 is carried.
Point of order?
Yes?
Mr.
Four
Garrison mentioned that he didn't hear the microphone was on. Does he need me to repeat what I was just said? Or? Is he good?
He's smiling. I think
He's good?
he's,
Okay, we're good? Okay.
thank you, Mr. Moore.
Sorry, you're right.
4 nays.
Yes, sorry.
So, clause 2, we have a CPC Amendment 1. So Conservative Amendment 1. Any comments, or shall we go to a vote? Sure, Mr. Moore.
Amendment 1 quickly, Mr. Chair. CPC Amendment 1 is there recognizing that it seems to be the will of this committee. I don't want to be presumptuous, but the way, based on the last vote, it would appear that the mandatory minimums that are in place are at risk of being struck down, which, in my view, puts our communities at risk, particularly when there is a recidivist element, repeat offenders that are committing the same crimes, same types of crimes over and over. What our bill would do, in an effort to compromise, what our amendment would do, CPC 1, is reduce the mandatory minimum penalty from 1 year to 6 months. There is virtually all of the minimums that we deal with in Bill C-5 and Bill C-22, which came before it. I think the lowest minimum was 1 year. I don't think there was any that were below 1 year. Some of them were more than a year, but the majority of them were a year. And what this would do is acknowledging what appears to be certainly the will of this committee to deal with mandatory minimums, but also acknowledging the cry from the public right now that there be real consequences for serious crime. What this amendment would do is an effort to kind of extend the olive branch and say, okay, if 1 year is too much, then 6 months that would take someone off the streets, hopefully get them some of the help that they need, but also show that there has to be a level of confidence in our justice system that if you commit some of the serious firearms offenses and other offenses contained in Bill C-5, that we as a parliament say, yeah, you commit an offense like that, there needs to be some period of incarceration. So this amendment would lower from the mandatory minimum penalty from 1 year to 6 months for using a firearm in the commission of an offense.
Thank you, Mr. Moore. Mr. Garrison?
Thank you very much, Mr. Chair. I do have to say, Mr. Moore, by your own logic, this would make the Conservatives soft on crime because you have always argued that the mandatory minimums do something to affect crime. And what we heard repeatedly from witnesses and what we know from all of the peer-reviewed literature in criminology is that mandatory minimums do nothing but increase jail time. They do not have a deterrent effect. They do not, by increasing jail time, make people less likely to offend. And in fact, if anything, the literature shows it makes people more likely to reoffend. So I think you're right in identifying that everybody around the table is interested in keeping the community safer and preventing more victims in our society. What we disagree on is whether mandatory minimums. In this case, I'm of course going to vote against your amendment because it restores a mandatory minimum that C-5 would be.
Thank you, Mr. Garrison. I had Ms. Briard, and then we have Mr. Morrison and Mr. Brock.
Merci, Monsieur le Président. Effectivement.
Thank you. I agree with Mr. Garrison, and the fact of removing MMPs doesn't reduce sentences. There is more discretion afforded to the judges, in fact, and it doesn't mean that offenses will be taken any less seriously. We will vote against.
Merci. Thank you, Ms. Briard. Next to Mr. Brock.
Actually, Mr.
Morrison, I
was
couldn't
ahead
see
of
which
me.
one had first, so Mr. Morrison, go ahead.
Thank you, Mr. Chair. Yeah, I think that, when we talk about the witnesses we had in, there's two groups of witnesses. We had people supporting offenders, which we need to look at, and I actually just gave a speech about that recently because I think that's very important. But when we had the victims come in, it was a kind of certainly a black and white picture. The victims were certainly extremely upset, and with the whole bill they were upset with. And in looking at the victim side of it, if we just drop the offenders, because victims should be first, in my opinion, and then we should look after the offenders, for a period of 6 months, which is reasonable, and I think it still shows, it demonstrates to Canadians looking at public safety that we as a government are still interested in keeping our streets safe and supporting those victims. And this is pretty serious offenses. I would think in a lot of cases our judges would be handing out more than 6 months, so it gives them that discretion to do more when the offense warrants it, but it also gives them the discretion to do the 6 months. So from what we had for witnesses, especially the victims, I feel we're missing the point of where Canadians stand if we start looking at thinking that these violent offenses are something that we should be completely removing the mandatory minimum penalties.
Thank you, Mr. Morrison. Mr. Brock?
I want to start off by highlighting the talking points that the government has repeatedly used when this bill was introduced at first reading, at second reading, what we've heard from committee members, from the government committee members in their questioning of witnesses, that, and in particular, the Attorney General, the highest legal officer in this country, that the whole purpose behind Bill C-5 is to make a significant step to once and for all address the over-incarceration of Indigenous offenders and other marginalized individuals in the country. And while I be the first as my colleague, Mr. Nakvi, in his previous capacity as the Attorney General of Ontario, was my boss, and certainly in his tenure would give us instructions from time to time to be ever cognizant of that particular fact and look at ways where prosecutors in Ontario, and I can only speak for Ontario, would be afforded the additional tools to exercise the appropriate discretion. Crown attorneys are vested with an enormous amount of power when we receive a case. When we receive a case, it's a Crown brief, it's an indication of what the accused name is, what the offense is, perhaps a summary of the salient facts. But apart from a particular Crown, such as myself, being familiar with a surname that could be synonymous with an Indigenous offender in my community, or because of my experience as a prosecutor knowing repeat offenders, I may not know whether or not that particular accused falls within the class of individuals that this bill is designed to assist. So we take a position, we take a screening position as to what we believe the offense is worth. But through the process of the prosecution, which in an offense such as Section 85, and Section 85 offenses for the non-lawyers on this committee is generally most often committed in an armed robbery scenario, an extremely violent offense that impacts community safety. It's quite often done as a result of an addiction that someone has, a quick scheme to acquire money to feed that addiction, quite often targeting convenience stores and vulnerable members of our community. So we take a very stern approach that this cries out for a significant denunciatory sentence. But because of the process could take upwards to a few years to resolve, and quite often individuals charged with this offense will acquire defense counsel, and defense counsel will bring to the attention of myself and other Crown attorneys some of the other factors that we should be considering when we exercise our discretion. So there was opportunities, and this is a long-about way of me saying to this committee, and this is something that no one has spoken about in the House, and I've trying to have many opportunities to bring this up without success, is that it completely ignores the discretion that Crowns in Ontario, and I would like to think across this country, have reflected and are doing in their work to ensure we are addressing the over-incarceration issue. But when you're dealing with an offense like 85-3, as I've highlighted, the serious nature of this offense, and this is to Mr. Garrison's point. With all due respect to Mr. Garrison, I completely disagree with his interjection, because a message must be sent to like-minded offenders. The sentencing provisions in the criminal code mandate principles by which a judge must consider. This is over and above factoring in the Indigenous background. We're taking a look at the Court of Appeal decision in Morris, when you took a look at the impact of being a Black Canadian in an urban center, and whether or not that can be taken into consideration by a judge. The fact of the matter is that there is numerous jurisprudence, and I'm sure my colleagues at the DOJ will certainly back me up when I say this, that the predominant sentencing principles for this type of offense is denunciation, it is general and specific deterrence, and most importantly, separation from society. These are individuals that will not be getting a conditional sentence. These are individuals, regardless of an Indigenous background or a Black background will end up in jail. So in my view, this sets the appropriate bar, sending out a message to like-minded individuals, should you engage in this activity, you're not going to stop at go. Using the monopoly metaphor, you are going to jail. No ifs, ands, or buts. But with Crown discretion, there's ways of adapting and taking a look at the over-incarceration issue. And the last thing I want to highlight, and my DOJ colleagues can confirm this particular offense has been charter-proofed by the Ontario Court of Appeal and the British Columbia Court of Appeal in the decision of Mazzaros, 2013, post-Newer, Ontario Court of Appeal, and All Iswawi from the British Columbia Court of Appeal in 2017. Both cases stood for the proposition that this particular section and the mandatory minimum penalties did not infringe upon Section 12 of the Charter. Thank you, Chair.
Thank you. Next, Mr. Cooper.
Thank you very much, Mr. Chair, and I wish to speak in support of this amendment. I have to say that if it were a choice between maintaining the status quo or going where the Liberals and NDP want to go, which is to eliminate mandatory jail time for some pretty serious offenses, including the very serious offense of using a firearm in the commission of offense, I would prefer the status quo. And that is where I hope we arrive at. But looking at the submissions that were made by certain individuals who came before the committee by the Liberals and the NDP, and hearing some of the comments made by my colleagues throughout the very, I would submit, rather limited number of meetings we have had, that I'm not optimistic that we're going to go there. Instead, it seems that, blinded by ideology, the Liberals and the NDP want to move full steam ahead and simply eliminate these mandatory jail times, despite some very compelling testimony from witnesses who were victims of offenses, including firearms offenses, and from law enforcement. And there's so much testimony that came before the committee that is really calling on the members of this committee to put a pause on rolling back mandatory jail time for specifically firearms offenses. I think it would be helpful to remind committee members of some of that testimony. And there's a lot, and it's tough to know, frankly, where to even begin. For example, Andre Jelinet, who is a retired director from the intelligence division of the service of the Montreal Police, said in general about Bill C-5, there will be no deterrence. The message this sends to the police who confront these criminals, and the criminals he's speaking of are criminals who go out and commit offenses with firearms, quote, will only fuel discouragement and disengagement from these police officers. This does not bode well for our collective security. As a society, we are facing an abdication and a retreat that is certainly not a solution to the overrepresentation of communities supposedly targeted by this bill. People who live in neighborhoods where gangs and organized groups are very active feel totally abandoned by Bill C-5, he said. Just imagine how you would feel if you were the victim of an assault with a firearm? Just imagine, he said. I don't think you would feel any safer in your community knowing that this person would not be subjected to minimum sanctions. That's Mr. Gelane, who has very extensive experience in law enforcement on the front lines, dealing with perpetrators who go out, who commit serious crimes with firearms, who undermine public safety, and who terrorize communities and leave victims in their wake. He certainly said, as a starting point, don't go where you want to go, where the Liberals and NDP want to go. And I agree with him. Annie Sampson, who is a municipal elected official, represents an ethnically and culturally diverse area in Montreal that has been hit hard by firearms crimes perpetrated by criminals who use illegal firearms, said before our committee, these weapons have destroyed families, friendships, and lives. The message being sent at present is that because certain mandatory minimum sentences have been abolished, a criminal can commit a crime and get a reduced sentence while the victim may be traumatized for the rest of their life. Stephen Wall, another retired police officer, again from the city of Montreal, said, again generally about Bill C-5 as it pertains to firearms offenses, that, quote, Bill C-5 would trivialize the possession of arms for further use in criminal activities. It would give the wrong message to these criminals. I don't think this will coincide with the reality as we find it in the streets. Members of street gangs already feel completely immune and free passage. They are going to be supported in a number of crimes. They are already laughing at the justice system. They just mock it. Then there's Sergeant Michael Rowe, who came before the committee representing the Canadian Association Chiefs of Police. I saw the Minister of Public Safety earlier today, or perhaps it was yesterday, citing the Canadian Association of Chiefs of Police in answer to a question in question period. He said, for police officers, victims of crime, members of the public, and even offenders themselves, the circumstances which result in a criminal charge for most firearms offenses often result in a real impact to public safety, exposure to stress and trauma, which has a lasting impact on mental health and the erosion of public safety. And in that regard, he spoke with raising serious concern about mandatory jail sentences being rolled back by this Bill C-5. And as Mr. Brock noted, when we're talking about individuals who are charged under this particular section, we're not talking about folks who are going to walk away with a conditional sentence. We're talking about folks who are going to be spending some time behind bars in most cases. And having regard for the evidence that came before our committee about the prevalence of illegal firearms, that the fact that crimes are being committed by people that are often involved in gangs and organized crime, having regard for the fact that these witnesses told us that as it currently stands, there is a need to provide for denunciation, and having regard for the impact that these types of offenses have on victims and on the collective sense of security in communities, particularly communities that have a wide variety, a wide array of social issues, that this is not where I'd like to go, but again, it is a matter of saying there should be at least some maintenance, some assurance that if someone goes out and commits a crime using a firearm in the commission of an offense, that there ought to be at the very least a mandatory jail time, at least some preservation of that, and that's what this amendment does. So on that basis, given where this committee appears to be going, I think it's, I hate to use the word compromise, but that's essentially what it is to maintain at least some level of accountability in place. Thank you, Mr. Chair.
Thank you, Mr. Cooper. Mr. Moore?
Thank you, Mr. Chair. And just quickly on this, you know, in the context of the debate on Bill C-5 and then Bill C-22 before it, and this is not to be partisan in any way, but it's to illustrate that the idea, the concept of Parliament sending a clear message to Canadians, to victims, to criminals, and yes, to the judges that are presiding over sentencing, that is not a conservative notion in some way exclusively. And before we take what I think is a drastic step and possibly eliminate a mandatory prison sentence for some of these Section 85 offenses, using a firearm in the commission of an offense, I just want to quickly note that that section was first, that minimum was first introduced as far back as 1976. So in 1976 forward, since then, some of these have been on the books. And that doesn't mean we can never make changes. I get that, but some of these sections have lived on through liberal governments, conservative governments, and so on. All of them agreeing to keep these provisions in place. All the while, these provisions, although challenged, many of them upheld. So I think it's important to contextualize that, because if you listen to the debate, you would think that all of these mandatory minimums, and I'm kind of lumping a bunch of them together here, but all of them somehow came out from the previous conservative government, when in fact, you know, I've taken the time to look at all of the mandatory minimums being eliminated, and virtually all of them pre-existed the previous conservative government. There's only, and in fact, the mandatory minimums that were brought in under the Safe Streets and Communities Act or previous legislation, the current government has chose to keep those on the books, to not eliminate them. So I think it's important before we make a change like that to recognize some of these have been on the books for the better part of 50 years, and it's not something that just is a recent invention, but something that we should really consider very weightily as we deliberate on each of these clauses, removing what could amount to the only barrier between someone who's committed a serious offense and them being right back out onto the street. So, thank you, Mr. Chair.
Thank you, Mr. Moore. Shall conservative amendment 1 carry? Recorded vote.
Mr. Ananda Sangari,
No.
Madame Brière,
No.
Mrs. Dillon,
Mr.
Mrs.
Zuberi.
Dillon, it's Mr. Zuberi's substituting. Voting no.
okay.
Vote no.
Mrs. Diab,
No.
Mr. Nagvi,
No.
Mr. Brock, Mr. Cooper,
Yes.
Mr. Moore? Yes. Mr. Morrison?
Yes.
Monsieur Fortin?
No.
Mr. Garrison? Mr. Garrison?
No.
So we have 4 yeas, 7 nays.
So the First Amendment, Conservative Amendment 1 is not approved. Shall Clause 2 carry? Recorded division.
Mr. Ananda Sangari?
Clause 2.
Clause 2.
Okay.
Madame Brière?
Yes.
Mr. Zuberi? Ms. Diab?
Oui.
Mr. Nagvi?
Wait.
Mr. Brock? Mr. Brock?
He's calling your vote. We're voting no on Clause 2.
No.
Mr. Cooper? Mr. Moore?
No.
Mr. Morrison?
No.
Monsieur Fortin?
Oui.
Mr. Garrison?
Yes.
7 yeas, 4 nays.
7 yeas, 4 nays, it's carried. Clause 3, we have a Conservative Amendment 2. It's part 2 of the package. Shall Conservative motion to,
Oh,
you
I'll
want to-
just
sure.
speak to that really quickly. For this section of the code, what our amendment would do again, is to replace the 1-year mandatory minimum with a 6-month mandatory minimum. And Mr. Cooper kind of reminded me of something that I think it is important that I put on the record is in no way, shape, or form would I want anyone to think that I think the mandatory minimum should be reduced in these serious firearms cases. But what we're attempting to do is to salvage some form of statement from Parliament denouncing the very serious firearms offenses that we're talking about here. And these are, under this current section, in the case of a first offense, under Section 92, sub 3, first offense to a term of imprisonment not exceeding 10 years. In the case of a second offense, to a term of imprisonment for a term not exceeding 10 years, and to a minimum punishment for a term of 1 year. In the case of a third or subsequent offense, to imprisonment for a term not exceeding 2 years, less a day. And, I think that we are talking here about some of the serious firearms offenses that we're seeing in the headlines today. Just to be clear, we're talking about the commission of an offense with a firearm, and these are some of the more serious offenses. And I want to draw because not all of these are exactly the same. There's not just a series of mandatory minimums that this Bill C5 eliminates. We have to put each and every one of them into context. And, I'm hopeful. I mean, we've seen 2 clauses, Carrie. I'm hopeful that on some of these clauses, we might take a look at what the impact is, and we might give it some thought and say, you know what, in this case, we should maintain a clause that perhaps has been in the criminal code for half a century. So, but I do want to, and I'm going to ask a question of our witnesses, but to walk us through the process under this particular section, because I want to draw the attention to the committee that the minimum punishment in the present section is only triggered on a subsequent offense. The escalated minimum punishment, a term of imprisonment for 2 years less a day, is only triggered by a third offense. So we heard testimony from police and from community members and from victims groups that said their concern is not with the one-time offender, the person who innocently got caught up in with a bad crowd and committed an offense. But what we're talking about here is an individual who is deeply involved in serious crimes that by definition cause harm to their fellow Canadians. But even at that threshold, so it's bad enough, to be charged and found guilty of one offense. But even at that threshold, it's not until you get to a second offense. So you've committed a crime under this section. Now you've gotten out, you've committed the same crime, you've victimized another Canadian, and only now we're saying, okay, now you need to serve 1 year in prison. 1 year in prison. That's not after the first offense. That's after the second offense. Now, picture that same individual. They've been found guilty twice of a serious firearms offense that involves victimization of fellow Canadians in our communities, whether rural or urban. Now, they're out again on the street, having been afforded the opportunity for rehabilitation and a course correction. Now, a subsequent third offense for which they have been found guilty under our criminal code, with the full benefit of our Charter of Rights, the full benefit of a fulsome defense under our Charter. They've been found guilty a third time, and all we are saying as a parliament is that for a serious firearms offense involving victimizing other Canadians, a minimum of 2 years. And even that is being stripped out of our criminal code by Bill C5. Even that. And the reason I'm speaking about this, Mr. Chair, is that I think, again, it's really important for committee members to think about it, because I know not all of us dwell on each of these clauses every day. We're all busy. We have constituents. We have people that are calling in because their passport that they went to get back in February still hasn't arrived. Well, the point is we're all busy people. We all have diverse challenges, and I think this is that moment when we're at this table that we draw our attention to the really profound impact that we have on Canadians' lives through the criminal code. We heard witness testimony from victims, and it really is bothersome sometimes when some witnesses would come and they would speak for their introduction, and but they never mention victims. And in virtually all of these cases, there's a victim involved. And when we listen to the victims, of course, I will not deny, when we listen to the criminal defense bar, absolutely, they say, get rid of these mandatory minimums that are so troubling my client. We don't want them. But when we listen to victims, they said it's an absolute affront to them that we would reduce the mandatory sentence that the person that victimized them would receive. So I guess the question that I have through you, Chair, to our witnesses is maybe to distinguish subsection 92.3 from some of the others, that the minimums we're dealing with here are not for first-time offenders, that they're for repeat offenders, in some cases three times repeating. So the other thing I'll say, and I throw this out to committee members. I mentioned the case that we just heard about NHL star Mitch Marner and the carjacking that happened there. And you know what? He's no more important than every other Canadian. The only reason we're talking about that is because we all know who he is. He's famous. What about the people that aren't Mitch Marner, that had their car jacked from the same parking lot the week before? They're important too. They're Canadians too. But the point I'm going to make, and I'm guessing it's 100% true, is that if someone was convicted a first time, they were caught by the police, they committed an offense, caught by the police, had a trial, found guilty, and sentenced. And then there was a second time, and then there was a third time. I don't think if I asked every one of these committee members if they truly believe that those are the only 3 significant criminal code offenses this individual had committed, I don't think anyone would believe that. These are the ones that people are caught for. It's one thing to get caught, then it's another thing to get convicted under our system. So they've been caught, convicted, not once, not twice, but 3 times. And that's the minimums we're talking about. So through you, Chair, to our witness, if you could walk us through a bit this clause and its application, and at each stage the triggers and the consequence of that trigger.
A quick, just point of clarification. I'm just wondering, because I'm getting a little confused here. So I'm wondering if we could just separate the questions from the debate. So if there is a question, maybe pose that first and debate, or vice versa. But I think this kind of, going into a discussion and then a question, I think just does make this confusing, and frankly, I think may not be the best way to move forward.
Thank you, Mr. Dunson. I think, Mr. Moore, you're able to ask questions however you want. However, I think when you're making statements and then a question and a statement, it might be confusing for the witnesses just to make the statement at the other.
Next time I'll ask a question, then a statement, then back to the question, then a statement. Gotcha.
Over to the witness.
I'll be very quick. Mr. Moore accurately described the sentencing implications. So on a first offense, there is no mandatory minimum penalty prescribed. On a second offense, there is the mandatory minimum penalty of 1 year, and on a third offense, a term of 2 years less a day, mandatory minimum penalty. This, just very quickly, this offense targets, in short form, illegal possession of certain things. So in respect of firearms, where somebody possesses a firearm, they know that they don't have the necessary paperwork to possess it. And that's the offense that's targeted here. It also targets things like possession of prohibited weapons or restricted weapons, and those are itemized in regulations enacted under the criminal code. So it could be things like butterfly knives or ninja stars, things like that. So that's the purpose of Section 92.
Thank you, Mr. Chair. So that my question part is over. You've answered it thoroughly, and I appreciate the answer. And now back to my point. Every day in the House of Commons, for the last number of weeks, the subject of gun crime has been coming up, and no matter what newspaper you read or radio station you listen to or social media you engage with, you're hearing about firearms crime in Canada. And what we're dealing with here is individuals who are in illegal possession of firearms. Not by mistake, but because they're engaged in criminal activity. I should remind the committee that we're dealing with this deals with the very issue that Canadians are asking us to grapple with, and that is illegal firearms in Canada, the possession of those illegal firearms by criminal elements, not by duck hunters, not by sport shooters, not by the poor guy that's jumped through all the hoops and maybe inherited a firearm from their grandfathers, and they've jumped through hoops to get licensed, and they do safe storage, and they have a license if they have to buy ammunition, and they're subject to the full weight of the law. We're talking about people here that are flooding our streets with illegal firearms. We know they come in vehicles across the border. We know they get smuggled across the border otherwise. We know that, in fact, and I hadn't thought of this, but criminals are, the law is always playing catch up with criminals, using a drone to drop a bag of handguns from the U.S. into Canada. So these are how some of the people who are going to be convicted under this section, that's how they will have come into possession of these illegal firearms. By definition, these people are in illegal possession of the firearm, meaning they're not licensed. They're restricted. In Canada, thank goodness, and Gary, I guess this is a bit of argument, but thank goodness, you used to have to have a registration on a non-restricted firearm. That was called the Long Gun Registry. It was supposed to cost $2 million. I think it ended up costing $2 billion. And this is important because previous government, conservative government, ended the Long Gun Registry because it was targeting the exact wrong people. So if you have a crime problem, it is my philosophy, and I think it's the philosophy of those on this side, is that if you have a crime problem, you go after criminals. When I saw in my own riding, senior citizens lining up to get their firearms license, I thought to myself, how is this making Canada a safer place? If someone's going to line up for an hour to get a firearms license so they can possess a firearm, a shotgun, or a rifle that they inherited, how on earth is that making Canada safer? So that was the gun registry legislation, and we committed to ending the Long Gun Registry, and we did that. And Canadians are better off for it. We're all better off for it because in spite of all the money that's spent globally right now and with the pandemic and everything, there is finite resources. So dollars that we spend at the federal level chasing good guys are dollars that can't be spent chasing bad guys. And we heard all kinds of witness testimony on this from police that said they're under-resourced. They don't have the resources sometimes to go after the bad guys. So I want to juxtapose what I just said about legislation that goes after the good guys. This legislation that we have before us, subsection 92, sub 3 of the Criminal Code, is all about the bad guys. These are people that haven't got it right the first, second, and now the third time. I think in light of everything, I would urge real caution in us saying, think about what we're saying. We're saying that we as parliamentarians think that you can be in illegal possession of a handgun in Canada, not licensed, restricted weapon, and you can be found guilty of that. You can possibly not go to jail. And then a month later, you could do the same thing and go before the courts, be found guilty, not go to jail. And then a month after that, theoretically, you could do the exact same thing. And what I'm starting to hear is a message. And it's the message that we heard from witnesses that they didn't want us to send, is that you can get away with crime in Canada, and you can get away with gun crime. And part of the issue with, with gun crime is illegal guns. And this section is all about illegal guns. So I'm urging extreme caution before we vote on this Clause 3, that we think about the message that we're sending, not only to the criminal element. They're getting the message loud and clear, is that you can do whatever the heck you want and not face a consequence under this bill, but also to victims, to people that have been victims of gun crime. And, I don't need to explain to you guys, I mean, it's in every one of our papers. There's victims of gun crime every day now in Canada. So, I would strongly, strongly urge members to vote against Clause 3.
Mr. Brock, and then I think it's Mr. Morrison and Mr. Cooper.
I can't highlight enough the import of my colleague, Mr. Moore's commentary about the nature of this particular offense. This is an offense, where I disagree just a little bit with my colleague is he made a reference, and I don't know if it was a reference to this particular section or just in firearms in general, that firearms generally have a victim component to it. I view this more in a regulatory format as opposed to a victim-centric type of offense. So that's the beginning of my my discussion, Mr. Chair. I do have a question, so maybe I should put the question to the DOJ witnesses first. In the amount of time that I had to prepare for today's meeting, I didn't have an opportunity to do a charter compliant research on this particular section. Are either of you aware of the jurisprudence across the country at the appellate level as to whether or not this section has been charter-proofed?
I only have limited information, and I have one, it's a bit dated. I do have a lower court decision striking, finding the provision unconstitutional, but I don't have the specifics around whether that was for the second offense or the third offense. We'd have to do some more digging on that.
But a lower court decision in a particular province?
A lower Ontario court decision.
Okay.
Yeah.
Okay. The other aspect, and I'll move on to debate, is that unless you're living under the proverbial rock, people in this country know that when you're in possession of a weapon, that it is a highly regulated device. In fact, Canada leads the world in terms of the licensing requirements, the courses that you have to take, the cost associated with it, the rules and regulations with respect to purchasing the firearm, registration of that, transporting that from the actual place of purchase to your home, the actual storage, the makeup of the container by which you store it, the separation of weapon and ammunition, all of that widely known across this country. And the reason this is important for this committee to hear is that I have heard, as a new parliamentarian, when this bill was introduced, that this was targeting the low-risk, first-time offender. This isn't what 92 talks about. In fact, just today in question period, my colleague, Mr. Ananda Sangari, talked about we're not punishing those first-time offenders, those low-risk offenders. There is a built-in safety mechanism already legislated in the criminal code. A first-time offender, to Gary's point, to the Attorney General's point, to the Minister of Public Safety, all the other ministers I've heard from, the backbench that I've heard from. There is a built-in safety mechanism because a first-time offender who finds himself mysteriously in possession of a weapon, loaded or not, without being a licensed holder, which could attract the attention of the police and hence a charge, is not going to jail on a first offense. The section talks about the maximum being 10 years. The language in the case of a first offense to imprisonment for a term not exceeding 10 years should never be synonymous to the non-lawyers on this committee as being applicable to a starting point of jail. It doesn't talk about that. And in my version of the criminal code, and I've always used Tremier's because I find it extremely helpful. There's annotations, there's case law, there's charter analysis. Who's laughing? Oh, I'm sorry.
I
Okay.
prefer the Martins.
Oh, yeah, there's Martins. Okay. You like Tremier's? Okay.
I like Martin.
So, I just lost my train of thought for a second. It'll come back. It'll come back, Mr. Nakvi. It'll come back. There's a section in my code, and I don't think Martin's has this. You might want to reconsider this, Gary. It's an offense table. And Mr. Nakvi can appreciate this because whenever you look at an obscure offense, and I'll be the first to admit, there are a lot of firearm offenses, and they're nuanced, and you got to be very careful with the language. You got to be very careful in terms of how you screen a file to see what options you have available to you. Now, under the offense table, for this particular matter, it says as follows, that a first-time offender for this particular section is eligible for a discharge, a conditional or an absolute discharge, the most lenient of sentencing options available to judges across this country, where that you can legally say to anyone who asks you, do you have a criminal record? You can respond lawfully, no, I do not. The only exception would be if a person were to ask or an employer were to ask, have you been convicted of a criminal offense? You would be lawfully required to say, I have been discharged. So that is available. Moving up the ladder of offenses, for a first-time offender, a suspended sentence, which is commonly known as probation. You keep your P's and Q's to yourself. You don't engage yourself in any further criminal activity. Depending on the length of that suspended sentence, your sentence is complete. A fine. No minimum, no maximum fine. A fine in probation or the conditional sentence, which we know Bill C-5 talks about. So, again, to my point, and to reiterate and highlight and support my colleague, Mr. Moore, the section already achieves what Bill C-5 is designed to do, and in particular, the emphasis and the talking points to try to reduce the over-incarceration. There is a built-in safety mechanism already in place. Thank you, Mr. Chair.
Thank you, Mr. Morrison. Thank you, Mr. Brock. Over to Mr. Morrison.
Thank you, Mr. Chair. And I just want to, there's a couple things. One, just not disagreeing with Mr. Brock, but I mean, I have in my history of policing, there's some people who don't know what a prohib firearm is, and some people might have a handgun, not realizing that it's prohibited. I mean, that's a possibility on a first offense. So in this clause that we're discussing right now, I can understand that first offense being where it's at right there, which is not having a mandatory minimum. I totally understand that. Getting to the second, or let's even talk about the third offense, serious offense, I couldn't imagine myself going to my rural community, standing up, saying to the people who are there who have been victims or are afraid, to say, oh, by the way, as a parliamentarian, we just struck down and we don't feel there's any need to have a mandatory minimum penalty for someone who's convicted 3 times of having a prohibited firearm. Like, I just can't imagine anyone here going home and saying, God, we had a great day in Parliament today. We just decided that we wouldn't have any mandatory minimums on a third offense. So I don't even know why we need to discuss this. We should be able to vote on this without even thinking about, of course there should be a mandatory minimum for the third offense. Thank you, Mr. Chair.
Thank you, Mr. Morrison. Mr. Cooper.
Thank you, Mr. Chair. And I think the fact that the Liberals are repealing mandatory jail time in respect to this particular criminal code section, which deals with mandatory jail time for not first-time offenders, as Mr. Moore, Mr. Brock, and Mr. Morrison have pointed out, but persons who are convicted twice and subsequent times to a serious firearms offense, that Bill C-5 is not as advertised. The Liberals have advertised this bill as being about first-time offenders, people who make a mistake, who might have been caught in the wrong set of circumstances, that in those cases that rehabilitation, seeing that such persons are not incarcerated, might be a better course. But, Mr. Chair, that isn't what this section deals with. This section deals with mandatory jail time for a serious offense of persons who are convicted more than once. So it's not a case of a one-off. It's not a case of someone just making a mistake. It's not a case of someone who was caught in the wrong place at the wrong time. It's a case that provides for a mandatory jail time for recidivists. And it's interesting on this theme of Bill C-5 not as advertised, and maybe the Liberals sort of saying one thing and doing another. We have a government that likes to talk a lot about firearms. They obsess about firearms, and there's good reason to be concerned about firearms out on the street being used by people involved in gangs, organized crime that have impacted and undermined the safety and security of our communities. Now, one would think that if one is concerned about public safety, that one would go after folks who go out and commit serious firearms offenses, who commit crimes with guns. But, the Liberals take exactly the opposite approach. Their approach is to go after law-abiding firearms owners while giving those who go out and commit crimes with guns a free pass. And that's what this rollback, this repeal of this particular section of criminal code with respect to the mandatory jail time provided for in it would do. It would give criminals a free pass. But there is some level of consistency with the Liberals, because in the last Parliament, my former colleague Bob Soroya introduced Bill C-238. Bill C-238 would have increased mandatory jail time for criminals convicted for being in known possession of smuggled firearms. We hear about the fact that most of the firearms that are used in the commission of firearms offenses are smuggled, illegal firearms from the United States, around 80% or so. Bill C-238 would have demanded increased accountability. But the Liberals defeated Bob Soroya's legislation. And I think some are newer members, but others are not. And one thing about Bob Soroya is that he always was a tireless advocate of his constituents. And he represented a part of Toronto that had experienced had serious issues with firearms-related crime. And he put forward a common sense bill to hold criminals accountable who knowingly are in possession of smuggled firearms, having regard for the fact that smuggled firearms are really the root of the problem when it comes to firearms crime. And what did the Liberals do? Well, I guess being soft on crime, they voted against it. And now, consistent with that soft on crime approach, they want to eliminate mandatory jail time for those who are in knowing possession of an unauthorized firearm, criminals who are convicted not on their first offense, but on their second and subsequent offense. It underscores, Mr. Chair, just how misplaced the priorities of this Liberal government are, and how their rhetoric doesn't align with their actions. They talk a good game, and a lot of Canadians buy into it. But when one actually looks at what they put forward in the way of legislation, or how they respond to legislation introduced by a then Conservative member of Parliament, Bob Soroya, very different than what you would think they would do based upon what they portray in public, on the campaign trail, in their talking points. And so, Mr. Chair, again, it's a case of a bill that is not as advertised, and it's an example, a further example of how misplaced the priorities of the Liberals are. We as Conservatives believe that firearms aren't the issue, but those who go out and commit crimes with firearms are the issue. That was repeatedly emphasized at committee by law enforcement. There were several witnesses who were asked that question, and in every instance, they said that that was the problem. But, you know, the Liberals want to go after the people who obey the law, but, you know, those who are recidivists, who commit offenses, who intentionally, who knowingly possess smuggled firearms, unauthorized firearms, they're not really interested in dealing with those problems. So, Mr. Chair, I'm hopeful that the members opposite will spend some time and really reflect on what is happening. And I would encourage them, because I don't think we're going to get through the clauses in the 25 minutes that we have left today. I would really encourage the members opposite to spend some time going through the testimony of what some of our witnesses who came before the committee from law enforcement and victims had to say about the impact that firearms-related offenses have, and then ask themselves how eliminating mandatory jail time for criminals who commit 2, 3, 4 offenses helps and makes sense. I'd be very interested in hearing how they would say that does make sense, and how it squares with their false advertising that this bill targets people who are caught up in the wrong place at the wrong time, who made a one-off mistake. This specific rollback of mandatory jail sentence in terms of Section 923 is not an example of that. It's quite the opposite. Thank you, Mr. Chair.
Thank you, Mr. Cooper. Mr. Brock.
Mr. Chair, briefly, I put to the Department of Justice witnesses whether or not they were aware of any appellate case law that dealt with charter-compliant consideration with respect to this section. They referenced one lower court decision in Ontario. My suggestion is we adjourn debate and voting on that particular clause until such time as that particular case is tabled for consideration, because one of the issues addressing one of the witnesses' comments was he was unaware whether or not that decision spoke to charter compliance with respect to the second or subsequent offense issue, and I think it's important for this committee to have that information before us. Thank you.
The only way I'm told we can move forward with that is if we have unanimous consent to postpone. So do we have unanimous consent to postpone? No.
Just a point of clarification. So we need unanimous consent to skip a clause? We have to go sequentially? We couldn't move on to clause 4 if they're not related? I'm sorry.
Mr. Brock, I'm told it's by majority to skip over, and we'd have to have a vote if we want to skip over this motion, go to the next motion, and then study this amendment and, this clause and this amendment afterwards. So if you'd like, we can take a vote to skip.
Chair, I think it's probably wouldn't take a ton of time to get that information for our next meeting. So I would think we should skip clause 3, move to clause 4, and come back to clause 3 at our next meeting.
To vote, would you, all those in favor of skipping clause
Request a roll call.
with a roll call?
Before we do that, can I get some clarification under what authority the clerks are referencing that particular clause?
Sure. It's under Chapter 16 of the Legislative Act. I think it's page 767. Clauses allowed to stand. The committee may, by motion, decide to stand a clause or group of consecutive clauses en bloc. Debate on a motion to postpone consideration of a clause is limited to the issue of postponement and may not touch upon the merits of the bill or the clause in question, unless provision to the contrary is made in the motion. Clauses which were allowed to stand are considered after all other clauses of the bill have been disposed of. Recorded vote. All those in favor of postponing hearing of Clause 3 and its amendment?
Mr. Anand Dasangari.
No.
Madame Brière.
No.
Mr. Zuberi.
No.
Mrs. Diab.
No.
Mrs. Shannon.
No.
Mr. Brock.
Yes.
Mr. Cooper.
Yes.
Mr. Moore.
Yes.
Mr. Morrison.
Yes.
Monsieur Fortin.
No.
Mr. Garrison.
No.
So we have
4 yeas, 7 nays. The motion to postpone is defeated. We'll now go to a vote on Conservative Amendment 2. Shall Conservative Amendment 2 carry? Recorded vote.
Mr. Anand Dasangari.
No.
Madame Brière.
No.
Mr. Zuberi.
No.
Mrs. Diab.
No.
Mrs. Shannon.
No.
Mr. Brock.
Yes.
Mr. Cooper.
Yes.
Mr. Moore.
Yes.
Mr. Morrison.
Yes.
Monsieur Fortin.
No.
Mr. Garrison.
No.
So that's 4 yeas, 7 nays. The amendment is not carried. I'm excited. I get to flip the page. Shall Clause 3 carried?
Mr. Anand Dasangari.
Yes.
Madame Brière.
Oui.
Mr. Zuberi.
Yes.
Mrs. Diab.
Oui.
Mrs. Shannon.
Oui.
Mr. Brock.
No.
Mr. Cooper.
No.
Mr. Moore.
No.
Mr. Morrison.
No.
Monsieur Fortin.
Oui.
Mr. Garrison.
Yes.
Seven yeas, 4 nay, carried. Shall Clause 4 carry?
Mr. Anand Dasangari.
Yes.
Madame Brière.
Yes.
Mr. Zuberi.
Yes.
Mrs. Diab.
Oui.
Mrs. Shannon. Mr. Brock.
Yes.
Mr. Cooper.
Yes.
Mr. Moore. Mr. Morrison.
Yes.
Monsieur Fortin,
Oui.
Mr. Garrison,
Yes.
11 yeas.
7 yeas.
Zero, no, 11, 0.
Yep. 0. 11 yeas, no zeros. Clause 5, we have a conservative amendment, number 3. Mr. Moore?
So Clause 5 deals with, it prohibits the possession of a firearm, prohibited or restricted weapon, or prohibited device, or any prohibited ammunition that the person knows was obtained by the commission of an offense. This makes it very different than some other clauses that we will deal with in Bill, or we have dealt with, and we will deal with in Bill C5, in that this is not just the possession of a prohibited weapon. It's possession of a prohibited weapon that the person knows was obtained in the commission of an offense. And I think that is an important distinction to make. There is a mandatory minimum penalty currently of 1 year for offenders convicted on this offense when prosecuted by indictment. The same mandatory minimum does not apply if someone is not prosecuted by indictment, is prosecuted by summary conviction. So I think a distinction has to be made here between this and other clauses, in that the person knows was obtained in the commission of an offense. That's a higher threshold to meet than just being in, we'll call it simple possession, because that's a term that gets tossed around a lot, but simple possession of a prohibited or restricted weapon. But in this case, the person knows that it was obtained by the commission of an offense. Now, you may wonder, since I support us having a mandatory minimum penalty in this case, it seems abundantly clear there should be one. Our amendment would reduce the mandatory minimum from 1 year to 6 months. And the reason that I'm proposing that is that, as we've seen, as we've gone through this clause by clause, all the mandatory minimums that have been in the criminal code dealing with firearms offenses that Bill C5 has thus far dealt with have been eliminated. So our amendment, the conservative amendment, would maintain a 6-month minimum for possession of a firearm knowing its possession is unauthorized. And I think that is a really important distinction to make. So that's my commentary through you, Chair, to Gary. That's the commentary part. I do have a question. I'm going to make that distinction. If our witnesses, through you, Chair, could comment on if there's an awareness on that additional threshold and how prosecution and police go about meeting that threshold when this goes beyond other sections, in that, A, you have to prove the person was in possession under the law, in possession of the prohibited weapon, but B, for a conviction under this section, you have to go further and prove that the person knows it was obtained in the commission of offense. Could either of our witnesses walk us through that process and how, again, I'm trying to draw the distinction between this and the other section where a person may have no idea that the weapon was in their possession as the result of an offense. This has another threshold to meet, and I'm just asking if they could speak to that.
Thank you for the question. Mr. Moore is right in the sense that Section 96 has that additional element that the Crown has to establish knowledge on the part of the accused that the thing they possess is illegal. It was obtained by crime. Knowledge includes willful blindness, and knowledge can be established through circumstantial evidence, but it is a requirement that the Crown would have to establish, as well as some information to show that the accused knew that the thing they possessed was, for example, a prohibited weapon or restricted weapon, for example.
Just one last question through you, Chair. You mentioned the legal element of willful blindness. You know, I think people understand, okay, you absolutely know that this was in possession of a weapon obtained by the commission of an offense. You could establish that someone knew or ought to know that. But could you speak to the element of willful blindness, or if possible, even use a scenario whereby someone would be willfully blind to the fact that, and I'm thinking of scenarios, but if you could speak to the scenario where someone is willfully blind to the fact that that of which they're in possession of came about through the commission of an offense.
Sure. Willful blindness as a mental element requires some evidence that the accused deliberately refused to make further inquiries. So a scenario might be where somebody offers to sell this individual a thing, and their suspicion is aroused, and they deliberately choose not to further inquire to assess the legality of the thing that's being offered to them in those situations.
Thank you.
More. Shall conservative amendment 3 carry? You had, I didn't see any hands raised. Go ahead, Mr. Sorry.
Again, to Department of Justice officials, any research done with respect to charter compliance?
The MMPs that would be removed through this amendment have been previously held to be unconstitutional, including in the case R.V. Robertson, 2020, British Columbia Court of Appeal 65. That's the reference.
Unconstitutional, you say?
Yes, unconstitutional.
What section?
Section 96.
No, what section of the charter did it infringe?
It would be Section 12.
12.
Yeah.
Section 12.
Section 12. Yeah.
Okay, and only one Court of Appeal decision, British Columbia?
That's the information we have available with us now. There may be others, but we don't have that information.
When was the mandatory minimum created?
This one was enacted in 1995. The Firearms Act amendments. Yeah.
Under a Liberal government. Any appellate decisions apart from British Columbia where it's been constitutionally tested and did pass, was upheld?
With the information I have, I don't have any other appellate decisions that have upheld its constitutionality. I have some other lower court decisions, earlier decisions predating Noor and Lloyd, where it was upheld in Ontario and in British Columbia, 2004, 2010, and 2016. A BC case in 2018, which would have predated the decision that my colleague spoke to you about. A 2017 Ontario lower court struck the MMP as well.
Okay. And in your responses to my colleague, Mr. Moore, about willful blindness, there's also a concept of simply being reckless in terms of the origin of the weapon. Do you put the term reckless along the same continuum of willful blindness in the context of the mental element that is required for the prosecution to prove?
Recklessness is a slightly different mental element. It's similar to willful blindness. Because the provision doesn't speak to recklessness, it doesn't It isn't an essential element of the offense. Recklessness requires somebody to appreciate the risk that in this case they have a strong sense that the thing they possess was obtained by crime, and they don't care. Is the difference between willful blindness. So there's that subjective thought process that goes
So
on.
then would you disagree with the commentary in my Tremere's 2021 annotated criminal code that says that the critical feature of the mental element in this offense is knowledge? The defendant must know or be reckless with respect to the characteristics of the weapon that make it a firearm or other regulated item. The defendant must know or be reckless with respect to the spurious origins of the property, though not the legal character of the predicate offense. No ulterior mental element is required. Is that a phrase and description that you would agree with?
If
based on your legal
the
knowledge?
courts have read in recklessness to those distinct elements, then yes. But as a general matter in criminal law, if essential elements are stipulated, in this case they are knowledge and willful blindness as a substitute for knowledge, because criminal law is significant legislation in terms of its impacts on the citizenry. Courts typically interpret criminal law statutes narrowly. But that said, if you have case citations that have interpreted it broadly. Yeah.
That's why I asked you.
Yeah.
If I had case citations, I would make reference to that to the committee. Sometimes I do have citations in this version, but sometimes I don't. So those are the questions, Mr. Chair. And now I want to move on to debate. So in addition to my previous comments with respect to Clause 3, there is a feature of Section 96 that affords the prosecution discretion. And discretion, I'm going to highlight discretion I will highlight throughout much of my commentary because I think it's important to drive home this message, particularly when you hear a consistent message from the government that this bill is to address over-incarceration of Indigenous and other marginalized individuals, to give a break to the first-time offender or the low-risk offender. They don't talk about recidivism. They never talk about recidivism. We as conservatives do that, and to a certain degree the Bloc does. But that's where we are concerned about as a conservative team, because our focus is the protection of our communities from coast to coast to coast. And it's no wonder when I post various messages on my social media, either as a result of interviewing witnesses at this committee or making statements with respect to some of the weaknesses of this particular bill, I get a flurry of messages from across the country and in many parts of the United States that it's high time that a conservative politician or a Canadian politician actually puts the needs of the community before the needs of the offender. So I didn't think it would be that much of a stretch for my colleagues across the floor and beside the conservative bench to understand that we have a dual purpose here as legislators to try to improve the law, to assist Canadians, to assist those who find themselves in conflict with the law, particularly as a first-time offender, using the words of the Liberal government. This section contemplates that. This section contemplates the very scenario that the Attorney General made the very first time this bill was introduced at first reading. He said to the entire House, Mr. Speaker, and I'm paraphrasing, this is not an exact quote, Mr. Speaker, imagine a scenario where a person decides to have a few pops on a Saturday night. And for the benefit of my colleagues who may have sensitive ears, we're not talking about Pepsi. We're talking about alcoholic pops. Who has a few pops, finds himself in possession of a loaded gun, and decides to shoot wildly into a barn. How would you feel if that was your child who made the mistake of having too much to drink, found a gun, not even considering for 1 minute, maybe it was acquired through the commission of an offense, and chose to discharge that weapon into a barn, not knowing if there happens to be any farm hands or farmers or assistance to those farmers who may be inside the barn, or animals for that nature. But he used that example to highlight the import of this particular bill and the significance of trying to distinguish a first-time offender from a seasoned, dangerous criminal who finds himself or herself in possession of a weapon and shoots wildly, not knowing about the dangers that that presents. So Section 96 contemplates that. Section 96 is a hybrid offense where a Crown has the option to take a look at all the circumstances of the offense, to take a look at that person who had a few too many pops and found himself for the very first time in possession of a loaded weapon and shoots wildly into a barn. And say if that person just happened to be an Indigenous male from my riding on the Six Nations of the Grand River, the very largest First Nation in all of Canada, a First Nation that I'm very, very close to and fond to and fight hard every day as a politician to ensure that the inequities on that reserve are addressed at a federal level, that I worked hard every day as a Crown prosecutor to take appropriate steps to address the issue of over-incarceration. I now have the tools already under Section 96 to exercise my discretion to pull that unique offender away from the harshness of the punishment of a mandatory minimum penalty, most likely because we have a quote-unquote Gladue court, or we call it the Indigenous Peoples Court. I have the opportunity to find out why he had too many pops, why he found himself in possession of an illegal firearm, why he felt it necessary to discharge the firearm in the fashion that he did. Gives me an opportunity to explore all this racist and systemic issues that that person grew up in. Maybe he's a product of the residential school system. Maybe his parents were involved in that. Maybe his grandparents. Maybe he suffers from poverty. Maybe he suffers from housing inequities. Maybe he suffers from a lack of education. Maybe he suffers or she suffers, I can't discriminate here between males and females, from addiction issues. These are all rampant on the Six Nations of the Grand River.
Point of order, Mr. Chair. I hate to interrupt my learned colleague, Mr. Brock, but I see it is now 5 minutes past the time of adjournment.
I lost track of time. I'm sorry, Mr. Chair.
Well, if it's the will of the committee to continue, it looks like it's the will of the committee, we can continue.
Monsieur le Président, en ce qui me concerne, j'ai un...
Mr. Chair, I'm sorry, but I have another committee after this one, and I wouldn't mind having some time to have a meal in between committees, so I don't mind continuing for maybe another 5 minutes. But if we're just going to continue just to filibuster, I can't stay. I must go to my other committee.
We would be agreeable to continue the meeting, Mr. Chair.
Mr. Morrison. Mr. Brock.
Myself and Monsieur Fortin are involved in a 3-hour Emergencies Act committee hearing starting at 6:30. I have to get ready for that, so I'm not in a position to continue.
I'm told, I think somebody would have to do a motion to adjourn, and then we could have a vote.
Well, I'll put forward a motion.
Monsieur le Président, pour continuer la...
Mr. Chair, don't you need unanimous consent to continue the meeting?
Monsieur Fortin. Mr.
Well, I
Cooper.
think out of respect for Mr. Brock and Mr. Fortin, I will put forward a motion to adjourn.
Recorded vote, I assume?
Mr. Anand Sangari?
Juste une seconde. Pouvez-vous préciser sur quoi?
Can you tell me exactly what we're voting on? A motion to adjourn the meeting.
Sangari?
So to adjourn?
Adjourn.
No.
Madame Brière?
No.
Mr. Zuberi?
No.
Mrs. Diab?
No.
Mrs. Shannon? Mr. Brock?
Yes.
Mr. Cooper?
Yes.
Mr. Moore?
Yes.
Mr. Morrison?
Yes.
Mr. Fortin?
Oui.
Mr. Garrison?
No.
So we have 5 yeas and 6 nays.
So we have 5 yeas. So we'll continue. Next, I think I had Mr. Cooper. You were on the... Oh, you're not done? Okay, continue, Mr.
And
Rock.
out of respect for the well-being of all the committee members, may we have 5 to 10 minutes for a comfort break, please?
Do I need a vote on that?
Certainly, my Liberal colleagues won't deny that opportunity for me.
Just for a break, I can suspend?
Suspend.
We'll break for 5 minutes. I'll return back at 5:40. Thank you. resume our meeting. I think I was with Mr. Brock had the floor at the time. Am I right?
I have nothing further, Chair.
Okay. Mr. Cooper?
Wanted to ask the justice officials, they had cited one BC Court of Appeal decision. For clarification, was that a post-Nur decision? And if you could just remind me of the case as well as the other cases that you referenced but didn't name from Ontario and Manitoba, I thought you had said.
So I'll have to get you the names of the lower court cases. I don't have those immediately with me. The Robertson case from the BC Court of Appeal was 2020.
Okay. And you don't have the names of the other cases?
Not with me, no.
If you could provide them, that would be helpful.
Shall the Conservative motion 3 carry? On division.
On division, so no vote.
Okay. Shall
Monsieur le
clause-
Président, qu'est-ce que vous avez adopté en...
Mr. Chair, what did we just adopt on division? I didn't get it.
If we,
en division?
CBC, Conservative motion 3? I'm not right now either. I'm not getting a translation.
Yeah, we're not getting translation. Can we? We're not getting translation.
We're not getting a translation.
Can we just suspend for a minute?
Can we just suspend for a minute or two? Thanks. Understanding there was no translation services, so we're just going to do that vote again as Mr. Fortin could not hear the question. So shall Conservative motion 3 carry?
Non. Je demande le vote.
No.
Madame Brière.
No.
Mr. Zubiri.
No.
Mrs. Diab.
No.
Mrs. Shannon.
No.
Mr. Brock.
Yes.
Mr. Cooper. Yes. Mr. Moore.
Oui.
Mr. Morrison.
Yes.
Monsieur Fortin.
Non.
Mr. Garrison.
No.
So we have 4 yeas, 7 nays.
So 4 yeas, 7 nays. The Amendment does not pass. Shall Clause 5 carry? Recorded vote.
Mr. Anand Dasangari.
Yes.
Madame Brière.
Oui.
Mr. Zubiri. Mrs. Diab.
Oui.
Mrs. Shannon. Mr. Brock.
No.
Mr. Cooper.
No.
Mr. Moore.
No.
Mr. Morrison.
No.
Monsieur Fortin.
Oui.
Mr. Garrison.
Yes.
So we have 7 yeas, 4 nays.
7 yeas, 4 nay. The clause is carried. Clause 6, and we have the first amendment is from the Green Party, and it's deemed moved according to House order of a while ago. In going with that, I'm going to allow Ms. May to say a few words.
Thank you, Mr. Chair. I'd like to start by, with all due respect and affection, correct you. This wasn't a House order. This is a committee motion that is a subterfuge which the Green Party objects to and has objected to since it was first used to deny us the rights we would ordinarily have at report stage. As a result of a motion in identical language passed in every committee every time we have an election, we now have, without proper process to change the ways in which the House of Commons works to address legislation, a bad habit which will, I'm sure, soon be referred to as some kind of law, that members of Parliament who are either independents or members of parties that do not have recognized party status are required on a very short timeline to turn around amendments and bring them to committees without the right to vote on them, without the right to speak much on them, and without the right to move them, which is why they're deemed moved, which puts me in an awkward circumstance because I can see what's happening in this committee. I support Bill C-5, but it doesn't go far enough. As we've looked at the Supreme Court decisions, we've looked at many Court of Appeal decisions all across the country, we know a number of things. And I'll go back to when C-10, the omnibus crime bill under Stephen Harper, went through Parliament. I was a member of Parliament. I fought very hard against it because there was absolutely no evidence that mandatory minimums worked to reduce crime rates. There was evidence to the contrary. The state of Texas was already removing its mandatory minimums while our Parliament was charging ahead to bring them in. So I support removing mandatory minimums. All of my amendments and a few others that are to a slightly different point seek to do more to remove mandatory minimums. They are expensive, inefficient. They pass the costs of incarceration onto provinces. There are many, many arguments as to why they don't make any sense. And, of course, the arguments we've heard a few times mentioned today, that we see disproportionate incarceration of people of color, of Indigenous peoples, at rates that are well known, so I won't repeat that evidence here. Just to say that my First Amendment, I can deal with it, but I want to also raise a larger point, Mr. Chair, which is that if I could, seeing the painful filibuster that we've seen the last 2.5 hours, if I could, I'd say, well, let's just take all my amendments that are inadmissible. Excuse me.
We just have a point of order, Ms. May.
Oh, sorry.
In reference to my friend's comments about a painful filibuster, I wholeheartedly disagree, and I find that quite offensive. We have an obligation to provide some commentary with respect to the amendments. A filibuster, again, from a rookie politician's point of view, is if I decided to open up my criminal code on page 1 and started reading all 1,400 pages. That's a filibuster. I didn't hear any points of order from anyone on this committee regarding relevancy. And in my view, my points and my colleagues' points were all relevant with respect to the points that we were making. So I wanted to bring that to your attention because I find that language rather offensive.
Brock, Ms. May, you can continue, I think.
I'd just like to apologize from the bottom of my heart to Mr. Brock. It was you're quite right. That didn't meet the definition of a filibuster, but it is a definite effort to slow down the review of this legislation. I had thought that since my First Amendment came up under Clause 6, that it would be attended to relatively early in a 2-hour committee hearing. So, and I'm not inexperienced, and you're quite right, Mr. Brock. It doesn't meet the definition of a filibuster, but it does place me, since I've brought forward most of the amendments before the committee tonight, in something of a quandary. I don't have the right to withdraw my amendments. They are deemed put forward by the committee. That is a motion, a committee motion that you yourselves adopted, unfortunately, and every committee has done so right through the system of the Parliament of Canada. And it does mean that I must proceed to present each and every one of these unless we can find a solution. I wanted to open with an offering that we know that a number of my amendments will be deemed to be inadmissible. And I would like to ask the committee that from my point of view, there's no purpose in me speaking to inadmissible motions, so I don't intend to. I want to make that clear right now. We can skip over anything inadmissible. Certainly the First Amendment I have before us is admissible and does go to what we should be doing, which is, as in the Noor case, as Chief Justice McLaughlin suggested, it would be better if Parliament got rid of all mandatory minimums and reviewed the use of mandatory minimums. She didn't go as far as to say get rid of them, but deal with it efficiently. Bill C-5 removes some, but not all, not even all the mandatory minimums that have already been struck down by courts. So it certainly would be preferable to find a way, as was noted by the court, it's better for Parliament to deal with this than to sit back and simply wait for the courts to handle them in a piecemeal way. The finding, of course, which I will quote from because I think it's central to this, is after reviewing at least 50 years of research on mandatory minimums, as the Supreme Court of Canada did in Noor, they found, quote, empirical evidence suggests that mandatory minimum sentences do not, in fact, deter crimes. And if we do turn to Statistics Canada, we can find that since 2020, well, rather from 2003, which was the peak of any crime rate in Canada, since between 2003 and 2020, crime rates in Canada have dropped by 30%. Violent crimes have dropped by 23%. So the discussion that's happened today in committee would lead anyone to think that we had a terrible crime wave. Any crime is unacceptable, any violent crime. I wish we were doing more for victims. We do not have good legislation. We do not have a good framework. We do not have good supports for victims of crimes, and we should. But in the context of mandatory minimums, all we're doing is removing the discretion that a judge would use on an individual case and potentially even giving a higher and more punishing sentence, if that's what you're looking for. But if we're looking for a criminal justice system that is affordable, that's fair and effective and reduces crime rates, this isn't it. And that's why my First Amendment calls on removing the provisions that impose mandatory minimums in cases where we have basically the trafficking in a firearm provisions. So by adding 99 bracket 2 and 99 brackets 3, Bill C-5 only deals with 99 sub 3, and my amendment would add 99 sub 2 and 99 sub 3 so that we would be more efficient in improving our criminal justice system by removing more mandatory minimums. And with that, that's the longest submission I will make. I know under the rules that you've adopted, we're to make a short submission, but I wanted to make an overarching approach this time because we do face we do support Bill C-5. We just don't think it goes far enough.
Thank you, Ms. May. Before I go to you, Mr. Moore, I'm just going to suspend for 1 or 2 minutes. I think there's some staffing change in the room services, so we'll just suspend for about 1 or 2 minutes. Thank you. going to be resuming in a minute, but we have to suspend at 6:30, not now. There was some mistake with the clerk. Is everybody in the room, if I could start? Yeah, at that time for house
Still going to be
services.
here at 6:30?
And Mr. Moore has the floor, and we are discussing Green Party Motion 1, Ms. May's Amendment 1.
Yeah, thank you, Mr. Chair. Ms. May, I guess the irony of saying that there's some kind of shock at the pace we were moving when Conservatives submitted 15 amendments to this bill, the Bloc 6, the Liberals 3, the NDP 3. Those are all a reasonable number of amendments for a bill that we've all been very vested in over the last couple of months. The Green have brought in 45 amendments to this bill. So I just find it passing strange that someone would make commentary on the pace at which we're going when they brought in 45 amendments. I am interested to hear on some of these Green amendments. I find it absolutely shocking to even see in print the idea that even, the Liberals clearly and the NDP have said, you know what, they don't like mandatory minimums for all offenses. But now, I'd love to hear an explanation as to why sexual exploitation, incest, bestiality, making child pornography, parent or guardian procuring sexual activity, making sexually explicit material available to a child, luring a child. These are all the absolutely disgusting offenses that the Green Party is saying we should have no mandatory minimum for. I mean, it's outrageous to dump all these amendments and then to basically gut the criminal code. And I don't know how many of you committee members have taken the opportunity to look at all of the Green amendments. And I don't blame you if you haven't seen them all, because there's 44 of them. But trafficking a person under 18, obtaining sexual services for consideration from a person under 18, procuring a person under 18. Is there a common theme? Almost all of them deal with children, in Canadian children being victimized in the most awful way, and the Green Party wants to remove the mandatory minimums. So I think that these amendments are frankly disgusting. I really do. I think Canadians would be appalled. I was appalled when I saw them in print. It made me want to gag to see the type of offenses that they're saying, nope, we don't want to send any. If the judge wants to say, walk out of here free, you can walk out free. I think it's appalling. That is my commentary on the Green Party amendments as a whole. On this one specifically, you know what? There's a reason why there's a mandatory minimum penalty for weapons trafficking with a firearm. There's weapons trafficking that can be other illegal weapons like switchblades, other knives. This is weapons trafficking in a firearm. It's the kind of stuff that we're dealing with, we're vested with, and it's irresponsible to basically dump the gutting of the entire criminal code on our committee. But those are my comments on that for now.
Point of order. I'm sorry, Mr. Chair, but I object to being mischaracterized as gutting the criminal code. Those offenses are offenses that would remain in the criminal code. We're objecting to the use of inefficient, expensive, and counterproductive measures, which are called mandatory minimums. All of the offenses that my colleague finds appalling and make us sick, make me sick too. They are disgusting offenses, and anyone found guilty should be prosecuted to the full extent of the law. But I prefer to leave it to a judge in the discretion of the judiciary, looking at individual circumstances and not blanket approaches which have been proven not to work. So I object to being put on the record and in any way, shape, or form as calling for gutting the criminal code. Those are offenses that will remain in the criminal code, and let's hope that they are fully prosecuted and that the punishment fits the crime. And when you use a blanket cookie cutter, you just say, mandatory minimum, you do not have a punishment fitting the crime. You reduce the discretion and the ability of the prosecuting attorney to get the right sentence. And you end up having some people going to jail who weren't guilty because they're so fearful of a mandatory minimum, they'll plead out even though they have not committed the crime. So I'm sorry, Mr. Chair, I wanted to also put on the record that due to previous commitments and not realizing this committee would run late, my colleague, the Honourable Member for Kitchener Centre, Mike Morris, is going to take over. So I withdraw at this point, but I wanted it recognized by the committee before I left that this is acceptable, that Member for Kitchener Centre replaces me in the committee.
Should be acceptable. I also apologize. I will have to suspend. There's some confusion with the clerk. It's suspending now for 30 minutes. So it's like the coffee, 30 minutes. 30 for the staff change, yes. So, for 30 minutes. I guess we'll resume. We were at a Green Party Elizabeth May's member amendment to Clause 6. We had finished, I believe, our debates on it. I had no other speakers on it. I just want to reiterate that if PV1 is adopted, Conservative Amendment 4 cannot be moved as they amend the same line. So, oh, can't hear? Okay, I'll repeat everything. Let me just, can I get order and quiet, please? Perfect. So as we're at Clause 6, Green Party Amendment 1, Ms. May's amendment. As I believe everyone on the list of speakers has spoken, I just wanted to make a note so that we're all clear once we vote for this. If the Green Party amendment is adopted, then Conservative Amendment number 4, which is going to come ahead next, cannot be moved as they amend the same line. So I just want to put that out there. That'll be the same in other amendments where we have multiple amendments of the same clause. So pointing that out in the beginning. Okay. So if no questions on that, I'm going to ask that shall Green Party motion 1 carry? Okay, recorded?
No? Yeah, sorry about that. I demand my name to be pronounced right. No.
No. Madame Brière.
No.
Mrs. Shannon.
No.
Mrs. Diab.
No.
Mr. Nagvi.
No.
Mr. Brock. No. Mr. Cooper.
No.
Mr. Moore.
No.
Mr. Morrison.
No.
Monsieur Fortin.
Non.
Mr. Garrison.
Yes.
So we have 1 yeas, 10 nays.
1 yea, 10 nays. Motion is not carried. Conservative motion, Amendment 4. Mr. Moore, would you like to say anything on it, or should we? Sure.
I think everyone's familiar with our reasoning on this, but I will just remind, because we just had that break, that this would, in no way do I want people to think I don't feel a mandatory minimum penalty of 1 year is enough in this case, but in a spirit of compromise, we're on that last vote, we almost had unanimity. I'm hoping that in the spirit of compromise, we would maintain a 6-month mandatory minimum for the offense of weapons trafficking.
Conservative Amendment 4 carry. Recorded vote?
Mr. Ananda Sangari. What?
No.
No, okay. Madame Brière.
Nope.
Mrs. Shannon.
No.
Mrs. Diab.
No.
Mr. Nagvi.
No.
Mr. Brock. Yes. Mr. Cooper.
Yes.
Mr. Moore.
Yes.
Mr. Morrison.
Yes.
Monsieur Fortin.
Non.
Mr. Garrison.
No.
So we have four yeas, 7 nays.
4 yeas, 7 nays. The motion does not carry. We have no amendments for Clause 6, so shall Clause 6 carry?
Mr. Ananda Sangari.
Yes.
Madame Brière.
Yes.
Mrs. Shannon.
Yes.
Madame Diab.
Oui.
Mr. Nagvi.
Oui.
Mr. Brock.
No.
Mr. Cooper.
No.
Mr. Moore.
No.
Mr. Morrison.
No.
Monsieur Fortin.
Non.
Mr. Garrison.
Yes.
Monsieur le Président, j'ai dit non, mais je voulais dire oui.
Mr. Speaker, I said no, but I really wanted to say yes. I'm sorry. I want to vote yes.
I think you can correct it, yes.
So it's 7-4. 7 yeas.
7 yeas, 4 nays. Clause 6 carries. Clause 7, we have a Green amendment, Green Party amendment number 2. Again, if Green Party amendment is adopted, the Conservative amendment 5 cannot be moved as they amend the same line. So shall Conservative, Green Party amendment 2 carry? Mr. Moore?
Yeah, I guess, yeah, no one from the Green Party spoke to this. I do want to, we're dealing in C5 amending a number of different provisions related to firearms and then provisions related to weapons. And sometimes people think of a firearm as a weapon or a weapon as a firearm, using them interchangeably. But in some cases, on the possession of a weapon, it does not include a firearm. In this case, I believe this mandatory minimum penalty proposed by the Green, the removal would would expand this to include a firearm when we're talking about weapons trafficking. I think in the legislation that that's currently before us on C5, there's a number of very important measures that mandatory minimum penalties are being removed for when it comes to firearms. But if our witnesses could just speak to the distinction on weapons trafficking and firearms trafficking that I think is important on this Green Amendment.
Yeah, thank you. Thank you for the question. Yeah, just very, very briefly, the 3 and 5 year MMPs for Section 100 possession for the purposes of trafficking apply to firearms, prohibited devices, ammunition, prohibited ammunition, and the 1 year MMP applies to prohibited and restricted weapons. So my understanding of the Green Party motion would be to repeal all of those MMPs in all cases, so not only for weapons, but also firearms.
Oh, no, sorry, I thought I heard Chair. Shall Green Party Amendment 2 carry? No. Recorded vote.
Mr. Ananda Sangeri. No. Madame Brière.
No.
Mrs. Shannon.
No.
Mrs. Diab.
No.
Mr. Nagvi.
No.
Mr. Brock.
No.
Mr. Cooper.
No.
Mr. Moore.
No.
Mr. Morrison.
No.
Mr. Fortin.
No.
Mr. Garrison.
Yes.
So 1 yeas, 10 nays.
1 yea, 10 nays. It does not carry. Conservative Amendment 5. Any debate, or would you like to vote? Okay, shall Conservative Amendment 5 carry?
Mr. Ananda Sangeri. Madame Brière.
No.
Mrs. Shannon.
No.
Mrs. Diab.
No.
Mr. Nagvi.
No.
Mr. Brock.
Yes.
Mr. Cooper.
Yes.
Mr. Moore.
Yes.
Mr. Morrison.
Yes.
Monsieur Fortin.
No.
Mr. Garrison.
No.
So we have 4 yeas, 7 nays.
4 yeas, 7 nays. It does not carry. Shall Clause 7 carry? Yes. Yes? Like to speak? No. Oh, okay. See, yes, Mr. Brock. Thought you were supporting it.
I'll get the hang of this, Mr. Chair. So in keeping with the spirit of the conservative amendments that you've heard Mr. Moore speak about, we're looking at a compromise. We are not supporting the elimination of that particular mandatory minimum as contemplated by Bill C-5. But we recognize, again, the spirit behind Bill C-5 in terms of the objectives to provide some recourse to the courts and to Crown prosecutors to exercise that discretion where required, but also to send a message to the community that should you engage in activities such as the section that contemplates criminal behavior, that you can expect not to be treated leniently, but you will be expected to serve a period of incarceration. We are reflective of the overall objective, and we feel that 6 months as opposed to the 1 year is an appropriate compromise.
Shall we go for a vote? Oh, we just let Mr. Moore and Mr. Hanzangari have a seat. Shall Clause 7 carry?
Mr. Ananda Sangeri. Madame Brière,
Yes.
Mrs. Shannon,
Yes.
Mrs. Diab,
Oui.
Mr. Nagvi,
Oui.
Mr. Brock,
No.
Mr. Cooper,
No.
Mr. Moore,
No.
Mr. Morrison,
No.
Monsieur Fortin.
Non. Oui.
Mr. Garrison.
Yes.
So we have 7 yeas, 4 nays.
7 yeas, 4 nays, it shall carry. We have a new clause, 7.1, proposed by the Green Party. It's the Green Party Amendment 3. I'm deeming that inadmissible. I'll read it out this time, but the other ones, I'll just deem the ruling. It seeks to amend Section 102(2)A of the Criminal Code, which deals with the offense related to alteration of a firearm. As House of Commons Procedures and Practice, third edition states on page 771, an amendment is inadmissible if it proposes to amend a statute that is not before the committee or section of the Parent Act unless the latter is specifically amended by the clause of the bill. Since 102(2)A of the Criminal Code is not being amended by Bill C5, it is therefore the opinion of the chair that the amendment is inadmissible. So we'll move to Clause 8. Clause 8, we have a Green Party Amendment 4, and again, if it's adopted, a Conservative Amendment 6 cannot be moved as they amend the same line. So shall Green Party Amendment 4 carry?
No. Mr. Alain Dasengari.
The Green Party Amendment 4 for Clause 8.
No. Madame Brière.
No.
Mrs. Shannon.
No.
Mrs. Diab.
No.
Mr. Nagvi.
No.
Mr. Brock.
No.
Mr. Cooper.
No.
Mr. Moore.
No.
Mr. Morrison.
No.
Monsieur Fortin.
Non.
Mr. Garrison.
Yes.
So we have 1 yeas, 10 nays.
1 yea, 10 nays. It does not carry. Now to Conservative Amendment 6. Would you like to speak or put it to a vote? Okay, Mr. Moore.
This clause is dealing with importing and exporting prohibited, restricted, non-restricted firearm, weapons, prohibited ammunition. The offense provides a mandatory minimum penalty of 3 years for the first offense and 5 years for second or subsequent offenses. In other cases, prohibited and restricted weapons and part components related to manufacture of an automatic firearm. I think it's important to know because automatic firearms, fully automatic firearms, are not, in spite of what people might think, they're not legal in Canada, even under our restricted category of firearm. We have non-restricted, we have restricted, we have prohibited, and fully automatic firearms are not legal in this country. There's a mandatory minimum penalty of 1 year for those that are manufacturing a automatic firearm. Clause 8 would remove that MMP. So it's for that reason that we are opposed to Clause 8, and also I had already mentioned on CPC Amendment 6 is an effort to reach a compromise that says, well, look, if you're in the business of manufacturing fully automatic firearms in Canada, possibly to be used, illegally, if you're convicted of that illegal activity, that you would serve at least a minimum of 6 months. That's an effort for compromise. And that's why we've moved CPC Amendment 6.
Mr. Morrison?
Is there any charter, any issues that have come up for our witnesses? Question.
We're not aware of any cases specific to the one-year MMP where it's been found unconstitutional. We are aware of a lower court decision in Quebec finding the 3-year MMP unconstitutional, but not the 1 year.
Okay, and just for debate purposes, we're talking about somebody who can actually change a firearm to fully automatic, which is a heart of organized crime, gang activity. That's, we all know, we sit in the House of Commons every day, we go home, we hear this every day. That's probably about as serious as it gets to a firearm infraction of a penalty. So I think we just have to maybe have a look at this one and really think about it when we vote for this. Thank you.
Debate only, no questions, and I'm putting this out to my Liberal colleagues to really reflect upon the purpose of this particular section and the type of criminal that it's capturing. It is not capturing the Indigenous first-time offender or the racialized Black Canadian offender. It's not targeting the low-risk offender. These are offenders who are knowingly engaged in a commercial enterprise to import and export weapons within our borders and internationally. And please reflect upon countless stories that we have shared as politicians over the last several months, what we are reading in the papers, what we are seeing on the television, about just the floodgates being opened, about the importing and the illegal gun smuggling that's happening at our porous borders. To my colleague Rob Moore's point, now we have drones who are circumventing our lawful borders to ensure that the commercial exchange of weapons continues. We have to draw a hard line in the sand as parliamentarians and look at the type of criminal that we are trying to capture here. We need to send a denunciatory message to these seasoned criminals that if you continue to do this, you will expect to go to jail. No ifs, no ands, no buts about it. This isn't a situation where you need to get a break. You have chosen an illegal enterprise and a way of life. This is so opposite to what your government has been preaching to Canadians with the introduction of Bill C-5. Please give that some consideration.
On a point of order, Mr. Chair, I think the debate should be directed through you and not to members.
All my comments for you, Mr. Chair. Thank you.
Sorry. Shall Conservative Amendment 6 carry?
Yeah, sure.
Yes.
Sure.
Mr. Anand Sangari. Madame Brière.
No.
Mrs. Shannon.
No.
Mrs. Diab.
No.
Mr. Nagvi.
No.
Mr. Brock.
Yes.
Mr. Cooper.
Yes.
Mr. Moore.
Yes.
Mr. Morrison.
Yes.
Mr. Fortin.
Non.
Mr. Garrison.
You're good, Mr. Garrison. Go ahead. You're not muted.
Okay, some little problems with the keyboard here. No.
So we have 4 yeas, 7 nays.
4 yeas, 7 nays. It does not carry. Shall Clause 8 carry?
Mr. Anand Sangari.
Yes.
Madame Brière.
Oui.
Mrs. Shannon.
Yes.
Mrs. Diab.
Oui.
Mr. Nagvi.
Yes.
Mr. Brock.
No.
Mr. Cooper.
No.
Mr. Moore.
No.
Mr. Morrison.
No.
Mr. Fortin.
Oui.
Mr. Garrison.
Yes.
So 7-4.
7 yea, 4 nay, carries. Shall clause 9 carry? Yes, Mr.
Point of
Moore?
So, did you rule on, I guess I'm following along, just want to make sure. Oh, so clause 9.1,
We haven't got to it yet.
you haven't got to it yet, okay.
I was going to
Clause
do 9 and then 9.1's right after.
That makes sense.
Yes.
Yeah, that makes sense.
You might have visited the aviation
Yes, yeah,
meeting a
for
little
sure.
bit.
No, I like that.
They're flying high.
No, clause 9 shall not carry.
Okay, so.
Mr. Ananda Sangari. Yes. Madame Brière.
Oui.
Mrs. Shannon.
Yes.
Mrs. Diab.
Oui.
Mr. Nagvi.
Yes.
Mr. Brock.
No.
Mr. Cooper.
No.
Mr. Moore.
No.
Mr. Morrison.
No.
Mr. Fortin.
Oui.
Mr. Garrison.
Yes.
So we have 7-4.
7 yea, 4 nay, clause 9 carries. Next, we have clause 9.1, proposed 9.1 from the Green Party Amendment 5. I will rule that this is not in order and non-admissible due to the Parent Act. I'll go by one. We have Green Party Amendment 5, so 5's already done, hold on. Green Party Amendment 6, so for the same reason, I'm going to rule this inadmissible, as it is not, it does not affect none of the act that it's proposing to amend is being debated. We will go to, so I will rule that not in order. And we have PV 7, Green Party Amendment 7, the same ruling. It's not as Section 153 of the Criminal Code is not being amended by Bill C5, is therefore the opinion of the chair that the amendment is inadmissible. And we have Green Party Amendment 8, also not admissible, as Section 155 of the Criminal Code is not being amended by Bill C5. It is therefore the opinion of the chair that the amendment is inadmissible. Green Party Amendment 9, same ruling. It's as Section 163A and B of the Criminal Code are not being amended by Bill C5. It is therefore the opinion of the chair that the amendment is not admissible. Green Party Amendment 10. Since paragraphs 163.12 to 4.1 of the Criminal Code are not being amended by Bill C5, it is therefore the opinion of the chair that the amendment is not admissible. Green Party Amendment 11, similarly, since sections 170 and 171 of the Criminal Code are not being amended by Bill C5, it is therefore the opinion of the chair that the amendment is not admissible, is inadmissible. Green Party Amendment 12, again, since paragraphs 171.1, 2A and B of the Criminal Code are not being amended by Bill C5, it is therefore the opinion of the chair that the amendment is inadmissible. Green Party Amendment 13, again, since paragraphs 172.1, 2A and B of the Criminal Code are not being amended by Bill C5, it is therefore the opinion of the chair that the amendment is inadmissible. Green Party Amendment 14, since paragraphs 172.2, 2A and B of the Criminal Code are not being amended by Bill C5, it is therefore the opinion of the chair that the amendment is inadmissible. Green Party Amendment 15, since paragraphs 173, 2A and B of the Criminal Code are not being amended by Bill C5, it is therefore the opinion of the chair that the amendment is inadmissible. Green Party Amendment 17, 16, since subsection 202(2) of the Criminal Code is not being amended by Bill C5, it is therefore the opinion of the chair that the amendment is inadmissible. Now to Green Party Amendment 17. Note again, if Green Party Amendment 17 is adopted, Bloc Amendment 1 and Conservative Amendment 7 cannot be moved as they amend the same line.
Can you repeat that, please? I'm a little bit confused.
So we're on Clause 10 now. Green Party
So did we pass Clause 9?
Clause 10. We went through, we've already voted on Clause 9. So we're at Clause 10, Green Party Amendment 17. And again, if Green Party Amendment 17 is adopted, then the Bloc Amendment 1 and Conservative Amendment 7 cannot be moved as they amend the same line. So shall the Green Party Amendment 17 carry? Would you like to interview? No.
Sure. This is the same justification as Ms. May shared for Green Party Amendment number 1, based on the principle of judicial discretion, that mandatory minimum penalties don't actually deter crime, and that they disproportionately affect marginalized populations. Thank you.
Thank you. Mr. Moore?
Yeah, thank you, Mr. Chair. And on this Green Amendment, I know you've ruled the others out of order, so I'm not going to speak to them, but it would have been interesting to hear Green members defend removing the mandatory penalties that Canadians have seen fit to put in place for making child pornography,
Yes.
making explicit material, luring a
member
child.
just had a point of order.
Point of order. I believe we're speaking to Green Party Amendment 17. Can the member speak to Green Party Amendment 17?
Mr. Moore, I would ask that you stick to...
I agree 100%. If I was Mr. Morrison, I wouldn't want to speak to all those things either. But, they dumped it into our committee, eliminating mandatory penalties for serious offenses against children. And now they get here and they don't want to speak to it. So it's a little confusing. If you're gonna put forward an amendment that deals with these type of sexual offenses against children, I think you should be prepared to speak to it and defend them.
Thank you, Mr. Moore. To Mr. Brock. Is it Mr. Brock or Mr. Morrison? I saw a flurry of...
Yes, I am going to speak on 17. Sorry.
Okay.
Yeah. On Green Amendment 17, which has been ruled in order, this amendment removes the mandatory minimum penalty even if the offense is in association with a criminal organization. So I think we're starting to, peel back some of the layers on the rationale on this piece of legislation. And we've already made it abundantly clear on other offenses that that there's significant concern around guns in Canada, and that the crimes being committed are not being committed by law-abiding farmers, duck hunters, sport shooters, but by the criminal element. This amendment takes things one step further and specifically references a criminal organization and repeat offenders. Now, most of these offenses that we're dealing with involve criminal organizations, and some of the amendments we spoke to do specifically reference recidivism and repeat offenders. In fact, we discussed a particular criminal code provision that provided for escalating escalating penalties, as there should be, on second and third offenses. So this Green Amendment 17 involves a criminal organization, or if the accused is a repeat offender. It's for those reasons that I will be voting against Green Amendment 17.
Did I think we have bells, so I will need unanimous consent to go through the bells, I guess, or no? Okay. Okay, so we'll suspend until the votes are over. Okay, I suspend. I think the convention is 10 minutes after the. now resume. I'll let you guys all settle down. And I think we were at Green Party Amendment 17 for Clause 10. And we had just finished with Mr. Brock, I believe? No, we're still carry on, and Mr. Brock.
Starting with me?
Yes.
Okay. So the Green Amendment is designed to take the existing Bill C-5 as proposed by the government and essentially wipe out every single mandatory minimum under Section 244. 244, discharging firearm with intent. Every person commits an offense who discharges a firearm at a person with intent to wound, maim, or disfigure, to endanger the life of, or to prevent the arrest or detention of any person, whether or not that person is the one at whom the firearm is discharged. The punishment section, which the Greens wish to annihilate, is that every person who commits an offense under subsection 1 is guilty of an indictable offense and liable where a restricted firearm or a prohibited firearm is used in the commission of the offense, or if the offense is committed for the benefit of or the direction of or in association with a criminal organization, to imprisonment for a term not exceeding 14 years and to a minimum punishment of imprisonment for a term of subnumeral 1 in the case of a first offense 5 years and sub-Roman numeral 2 in the case of a second or subsequent offense 7 years, and B, in any other case, to imprisonment for a term not exceeding 14 years and to a minimum punishment of imprisonment for a term of 4 years. Subsection 3 of 244 lists the provisions for subsequent offenses. I'm not going to get into that discussion. I'm looking at my Tremier's Criminal Code. I do see a section regarding charter considerations. From what I can see here, by way of an annotation, is that there was a Provincial Court of Appeal decision from New Brunswick, Regina versus Roberts, 1998. The minimum punishment provided for in that section does not offend Charter Section 12. So I will postpone my debate at this point, Mr. Chair, and I will turn to the Department of Justice witnesses. And gentlemen, in addition to that particular case, are you aware of any decision, whether it be a lower court or an appellate decision across this country that speaks to this particular offense?
Thank you for the question. We are aware of a number of decisions, and I'll just quickly go through them. A New Brunswick Court of Appeal decision from 1998 upheld the 4-year MMP.
Is that Roberts that I just read out?
I have MDR as the initials.
Do you have the citation?
1998 MBJ number 160.
Okay, I have 125 CCC 3rd edition 471.
Okay.
It could be one in the same case.
We have a 2011 decision from Newfoundland, provincial court upholding the 4-year. There is a very old 2017 decision, from Ontario Superior Court, REIS, R-E-I-S, REIS. And we're also aware of a 2018 decision from BC upholding the 5-year MMP as well. in that provision.
Okay, so the majority of the jurisprudence that you just referenced upholds the mandatory minimum penalties as it relates to the areas that Bill C-5 as drafted does not capture. Is that correct?
Yeah, so the 4 cases I referenced, 3 of them speak specifically to the MMP that would be repealed in Bill
Right.
C-5. 2 of those decisions, as I've said earlier, predate both Noor and Lloyd from the Supreme Court. One
Right.
follows Noor in 2015.
Right. And am I correct, because I don't have the actual bill in front of me, Bill C-5 speaks to Clause 2 sub B, which references in any other case to imprisonment for a term not exceeding 14 years and to a minimum punishment of imprisonment for a term of 4. That's what Bill C-5 is trying to eliminate, correct?
Correct.
For the benefit of myself and for the benefit of committee members, can you offer us some examples of what type of weapon is contemplated under Section 244 that is not otherwise delineated in subparagraph A?
So for the 4-year MMP, it essentially involves long guns that don't involve organized crime. So the 5 and 7-year MMPs relate specifically to prohibited or restricted firearms or any firearm. Just let me get the wording. Or if the offense was committed for the benefit of, at the direction of, or in association with a criminal organization. So that could be long guns and organized crime. 244-2B would encompass situations where a long gun was used, but it wasn't linked to organized crime.
Right. And are you both, either of you or both of you, in a position to opine, based on your legal experience, on any such cases where this type of criminal activity involved a long arm weapon, a rifle of sorts, used in the context of what we know as lawyers of individuals charged with this offense, to actually discharge it with the intent to wound, maim, or disfigure? When you're taking a look at the constellation of all of those offenders who are captured by the language in 244, are you offered to opine as to what percentage of cases we're actually talking about with the use of a long firearm?
I don't think I can give you that today, and I don't. I mean, the best we would be able to provide would be information just on charge data and under 244-2B, but we wouldn't be able to tell you a percentage breakdown as compared to handguns or restricted firearms today.
Right. And this is going to be a silly question I'm going to put to you, but this is the government's narrative, and certainly from the Attorney General's own words, his own mouth on day one when this bill was introduced in the House. The example that you've probably heard me reference already to this committee about perhaps an Indigenous young male deciding to have a few too many pops, alcoholic beverages, and grab a weapon and discharge that weapon wildly into a barn. Certainly that does not envision any scenario under Section 244, does it?
No, I think to the extent that scenario is captured in the offenses, I think it's 244.2, which is the intentional discharge while being reckless. So that's I think that's Clause 11 of the bill.
Because the prosecution has to establish that there was an intent to wound, maim, or disfigure, or endanger the life of, or prevent the arrest of, or detention of any person. The Attorney General, the leading legal authority in this country, offered Canadians a woefully inadequate description of what Bill C-5 is really trying to capture. Would you agree?
Well, I mean, to be fair, and we'd have to look back at the transcript, as I said, I do think the scenario he was reflecting on was the offense under 244.2, not sub 2 of the bill. So that is another offense that addresses similar conduct but different conduct. The difference between the two offenses, Section 244 is, as you've described, sir, in terms of the specific intent to wound, maim, disfigure. 244.2 was had its genesis in scenarios where it may be difficult to prove a specific intent to wound, but rather an appreciation that the consequences of discharging the firearm could put somebody at risk. And so that's the recklessness element of 244.2, where the accused turns their mind to the fact that they don't know with certainty that the building that they're about to shoot at is occupied. They strongly suspect it, and they decide to discharge in any event without regard to the consequences. And so that was the scenario, I think, that 244.2 was speaking to.
And I've often referenced this evening, and again, based on your current positions at the DOJ with your legal background, you would hopefully agree with me that this committee really cannot overlook the importance of prosecutorial discretion. Would you agree with that concept?
Yes, absolutely. Discretion is a key component, as
Right.
you know, as committee members know of the criminal justice system. From a constitutional perspective, we do know that discretion, the exercise of Crown discretion, can't save a decision, a finding of unconstitutionality from the Supreme Court's decision in Noor. So how a Crown chooses to proceed, whether it's by indictment or summary conviction, while it's important in terms of being able to respond to the circumstances as the Crown prosecutor sees them, as they're presented to them, it doesn't ultimately impact the outcome of a constitutional consideration
Right.
of a mandatory penalty.
Right. So those are the questions, Mr. Chair. I'll go back to debate at this point. So I just want to share with the committee that with the 18 years of experience I had as a Crown prosecutor, I can probably recall with some precision at least a dozen cases in my 18 years of prosecuting in the city of Brantford, Ontario, prosecuting in a small jurisdiction approximately 40 minutes southeast of Brantford, Ontario, a little town called Cayuga, which is very close to the Six Nations of the Grand River, as well as the Mississaugas of the Credit. Also had an opportunity of prosecuting in a smaller town known as Simcoe, Ontario, and for a period of time also in Hamilton. So I've had a cross-section of small rural communities with an attachment to an indigenous population, a mid-sized city, and large cities. And I can tell you that in that experience, the boundaries by which criminals commit gun-related offenses really has no boundary. It's as prevalent and dangerous as it is in a larger center, a mid-sized center, as it is in a rural center. But I can inform this committee that under the direction, and I will give credit where credit is due, to my colleague, Mr. Yakvi. I don't know if he is still, yes, he is. Mr. Yakvi is still with us. He had an exemplary, in my view, an exemplary track record as the Attorney General of our province. He insisted that policy reflect the appropriate balance in terms of how we hold offenders accountable, while at the same time not being overly restrictive in our ability to exercise decision-making unencumbered by Mr. Naqvi, unencumbered by the Attorney General, unencumbered by Crown Manager. It would only be a situation where a decision that I made was called into question. And if I didn't have the ability to justify the decision that I made and the considerations that I took before making that decision, so long as the decision was grounded in law, grounded in Crown law policy, and reflective of the circumstances of the offender, I had the backing of my former boss. I had the backing of my former Crown attorney in my jurisdictions, that the decision would be respected and would be upheld by my superiors. And the reason I'm saying this is because I was part of a team of close to 1,000 Crown attorneys in the province of Ontario. And we would often refer to the Association of Crown Attorneys of Ontario as the largest law firm in the country, the largest law firm that practices nothing but criminal law. And we've got Crown attorneys, fine Crown attorneys from coast to coast to coast. And I can only speak for Ontario, but I'm sure that the Crown attorneys in the other provinces would have conducted themselves in much the same fashion as Mr. Naqvi, to give those assistant Crown attorneys the discretion and the tools to make the right decision. So the reason I'm getting to a long about way of making my point is to really highlight that we as Crowns are not just walking robots, that we are human beings, that in addition to our legal responsibilities, we are citizens of our communities. We reflect societal views and values. And I've repeated this, and I'll repeat it until my career as a parliamentarian ends, that we have to, as parliamentarians, take steps to address the over-incarceration of Indigenous offenders. To take a look at the statistics, and we've heard this from several colleagues, about the percentage of male offenders and female offenders in our prison, which either meets or exceeds that 50% threshold in provincial institutions and federal institutions across this country, and you factor in the actual population of the Indigenous population in Canada, it is a horrible statistic. But I think it's a danger to say that in each and every case that when an Indigenous offender commits a criminal offense, such as a serious criminal offense, such as Section 244, that the default position has to be that we need to look at alternatives to incarceration. The sad reality, Mr. Chair and members of this committee, is that I recognize that there are indeed first-time offenders with an Indigenous background or a marginalized background, but there's a vast majority of those classes who are repeat offenders. And really, it's a sad statement on society because we have failed them as a government. Our Prime Minister in 2015 made the pronouncement during that election that there was no greater relationship that a government should have than with its Indigenous neighbors. I believe that. I live that. I have numerous Indigenous friends. Had it all my life. Born and raised in Brantford. Proud to continue to reside there. But we have to take a look at what's happening on reserves across this country. We had the Truth and Reconciliation Report, which came out years ago, and our current government is still grappling with the concept that you got to make this a priority. You have to address the calls to action. We have issues with respect to legacies and traumas of the failed residential school system. We have issues of a lack of appropriate housing. My community, my Six Nations of the Grand River, under the Harper government, was able to secure funding of almost $40 million to secure the rights and the ability to build a water treatment facility. And the sad reality is that that treatment facility has the capacity, Mr. Chair, to service all of its 25,000 residents and businesses on that territory. But to this day, because I think it was built in 2013 or 2014, so some 9 to 10 or 8 or 9 years later, to this day, that treatment facility serves 20% because they don't have the funding. The government dried up all the funding to ensure the necessary infrastructure. All the pipes were placed in the ground. So we've got numerous issues of lack of potable water. We still, and it's disgusting that in today's day and age, in the 21st century, in a leading democratic state as Canada, that we have Indigenous Canadians still with water boil advisories. It's inexcusable.
I mean, this is.
Point of order, Mr.
I'm sorry, I got the floor, Mr. Chair.
No, but
I do think it's important to talk about relevance here, Mr.
what's
Chair.
the
I will be
relevance?
glad to debate the member opposite on reconciliation and the efforts by our government, but I don't believe this is the forum for that. This is specifically on mandatory minimum penalties. That's the nature of the bill, and then I do want to stress that deviating from that, I think, really is disingenuous in this, at this moment, and I would ask that the member focus his comment specifically to the amendment at hand, especially with respect to MMPs.
Thank you, Mr. Nansegay. Mr. Brock, just reminding you, we're on Clause 10, particularly the Greens Amendment number 17, so it has to stay on
I know
that.
exactly where I am, sir,
Thank
but I'm very methodical when I do a deep dive analysis into legislation. It may offend it may offend my liberal colleagues, and I apologize to you that tend to be thorough. And quite often, it's a criticism that judges would make, and they say, "Mr. Brock, how long would you be in your closing statement or your submissions?" And I would say, "Oh, I don't know, maybe an hour or 2 hours," and they would laugh. I had one case where I spoke for 9 hours in my closing submissions. Now, I don't propose to keep my friends here till 3 o'clock in the morning, but I'm prepared to do that if necessary, because I think this is an important issue. And they may be angry, they may be upset. They had an opportunity at 5:30 when the matter was called to adjourn, where they came up with this notion, I suppose, that we were going to get through 70 amendments in 2 hours is just, it's nonsensical, quite frankly. But to limit my ability to be thorough in my responses, we're talking about over-incarceration of Indigenous offenders. Their bill, their talking points.
Exactly.
Not the Conservative government's talking points, the Liberal government. So it's very disingenuous for Ms. Diab to find, and Mr. now to Sangaree to find a lack of relevancy when I'm talking about Indigenous issues. I'm passionate about this, Mr. Chair, and I wish to continue my discussion.
You're more than welcome to continue.
Thank you.
Mr. Brock.
So I think before I was cut off, I was talking about the sad reality that many Indigenous communities are under water boil advisories. It's disgusting how this Liberal government can claim to be an ally to our Indigenous neighbors and have these individuals, hundreds, thousands, tens of thousands, suffering. Do you think it would be different if this precinct all of a sudden maybe would have had maybe a chlorine issue with our drinking water, just like we had in Nunavut on a couple of occasions where some diesel fuel got into the water supply? You saw how quickly the government reacted. You think it would be any different, okay, on this precinct if we had a similar issue, that immediate steps, regardless of the cost, would be utilized, deployed to rectify the situation? It would happen in less than a week. We wouldn't have to wait for years. And that's the legacy that this government, and this is the message that this government is sending to my Indigenous friends and my Indigenous neighbors across this country. So I talked about water. We have housing issues. We have lack of education. We have a lack of nurturing because, again, the whole concept of the trauma of the residential school system has prevented parents and grandparents. It's robbed them of social ability and social cues to raise their children, to guide their children, to be law-abiding and respectful. It's no wonder, under all of those circumstances, Mr. Chair, again to my earlier point, that there is a overabundance of Indigenous offenders who are engaging in very serious criminal activity. We heard from not only the chief of the Brantford City Police, we also heard from the chief of the Six Nations Police Service at this committee. Both of them are Indigenous, Mr. Chair. Both of them described an out-of-control situation on the Six Nations of the Grand River in terms of the lawlessness that exists. And quite frankly, it got to the point a few years ago, this is when I was a Crown Attorney, that there were strong recommendations by the Chief of Police to our community in Brantford that it may not be a good idea to travel on the Six Nations of the Grand River during the day, because at that time there was an abundance of high-speed chases. Six Nations of the Grand River at that point had a reputation of being the car theft capital of Canada. And it was a very lucrative trade for a lot of the Indigenous youth and young Indigenous males on the territory. It got to the point where they did not recommend that you travel during the day. So you have all of these factors, Mr. Chair, and it's no wonder that we find ourselves in a situation where we have far too many offenders of an Indigenous nature in our prison system, as well as blacks. I read numerous, Black Canadians, I read numerous newspaper articles, watched television programs, read articles online of the ever-increasing role that gang activity has in large centers The predominant racial makeup of most of these gangs, unfortunately, are black Canadians. They are actively recruiting black youth because there's very little opportunity in larger centers. And I know that as a government, and to a certain degree, even the Conservative Party during the last election, we talked at crime mitigation measures. We talked about ways that we can deter offenders away from the criminal justice system. At least the Conservative platform certainly referenced that, and I know the government's platform referenced that in the election, and they talk about that in the House. But what are they doing about it? Besides talking and meeting and using the words of the Minister of Foreign Affairs, convening, you know, time to put some action into your words. Instead of talking the talk, it's time to walk the walk. And if they're that serious about the overall impact of criminal justice reform, we need not only to take a look at the existing legislation, but to take a look at the underlying causes. And that's not being addressed. I know that's not a component of Bill C-5, but we don't want just Bill C-5 to be a Band-Aid to the overall significant issue. And we have to be mindful of that significant overall issue as parliamentarians. So the committee will probably be very grateful to know that I'm going to move on to a different area. I think I've canvassed my thoughts with respect to the Indigenous issues close to my riding. Now I want to do a deeper dive under Section 244. Because as a prosecutor, I've had, and I talked about this earlier, at least a dozen cases where I dealt with 244 cases, and all of them were essentially drive-by shootings or one gang shooting up another gang. One case in particular was outside a variety store that I attended every single day as a Crown attorney, going home for lunch, picking up a newspaper, and just before this particular crime that I'm about to share with this committee, I happened to be there 3 days before the offense occurred, and my vehicle is known to Brantford City Police. We have an understanding that we have to share our license plate numbers with the local police, so they are in a position to ensure that they could watch us and give us some protection. I've dealt with numerous cases, Mr. Chair, where my life was threatened, my family's life was threatened. I had to get resources in to beef up the security on my house, changing the locks, putting in bulletproof glass, cameras, surveillance, the whole litany of things I've dealt with. And I use this when someone will ask me, well, Mr. Brock, give me a day in the life of you as a prosecutor. And I could say, I don't know if I'm going to show up at the office and I'm prosecuting a shoplifting case or I'm getting ready for a homicide. It was that myriad of cases that I was dealing with. But given the experience that I had, Mr. Chair, it was more often than not that I would be handed the homicides, I would be handed the gang-related activities, I would be handed the shootings, I would be handed the child exploitation cases. So going back to the variety store issue, an officer sees me and he says, "What are you doing, Brock? What are you doing at this particular store, which had a notorious reputation for criminal activity?" And I fluffed it off. I said, "I'm just getting a newspaper. I'm not worried about it." 3 days later, around the same time that I was there, two individuals who had a prior beef, 2 o'clock in the afternoon, one's inside the store picking up a pop or whatever, comes out. Immediately, the offender is staring right at him, literally 6 feet away, with a handgun. He pulls out, the victim pulls out another handgun. They both shoot at each other. Broad daylight, 10 feet away from the front door of the very same variety store that I attended to pick up a newspaper. Luckily, both were pretty good shooters. They shot themselves. They didn't shoot any bystanders. But you can imagine the panic. You can imagine the fear, the confusion. That's what 244 talks about. This isn't the first time offender. This isn't the first time low offense related activity. Both of these individuals wanted to wound. Both of these individuals wanted to maim. Both of these individuals wanted to disfigure and endanger the life of each other. And that's what the Greens feel by eliminating the mandatory minimum penalties. This is going to address the over-incarceration issue. This is going to promote some sense of responsibility in an offender. I don't know where the Greens are coming up with their talking points, but I can assure you, Mr. Chair, they need to spend a day in the life of a prosecutor who's on the street daily dealing with these serious crimes. They are completely out to lunch on their talking points on this. It's dangerous activity. Not too long ago, members of this committee may have heard about the Just Desserts shooting in Toronto. Or was it Scarborough? Gary will probably recognize that. So I'd like to spend some time and just informing the committee about the circumstances of the Just Desserts shooting, because this was a 244 offense. The Just Desserts shooting was a notable crime that occurred in Toronto on the evening of Tuesday, April the 5th, 1994. Just after 11 p.m., a group of 3 men barged into the Just Desserts Cafe, a popular cafe on Davenport Road in Toronto's Yorkville, not Scarborough, Gary. One of the men was armed with a shotgun. The armed robbers ordered the 30 staff and patrons to the back of the store and took their valuables. One of the patrons that evening was 23-year-old hairdresser Georgina Limonis, who was there with her boyfriend. A dispute broke out when 2 male patrons refused to hand over their wallets. They were punched by one of the robbers. Soon after, the man with the shotgun fired and hit the victim in the chest. The robbers fled the restaurant. She was rushed to the hospital, and after surgery, she died at 2:45 on Wednesday morning. A security camera in the restaurant filmed the entire scene, but its low quality and lack of audio made it difficult to make out events and hard to identify the murderers. The police began a search for 4 men, the 3 who had been involved in the robbery and another who had helped them case the restaurant earlier. The police were criticized when the descriptions released of the 4 men was that they were 6-foot-tall black men. Many felt that such a vague description would do nothing to help capture the perpetrators and would merely enhance stereotypes of black men being criminals. A week after the shooting, Lawrence Augustus Brown was identified as a suspect, and he turned himself into police. Another of the 3, O'Neill Rohan Grant, was arrested soon after. That fall, Gary George Francis and Emil Mark Jones were arrested. Grant, Francis, and Jones were charged with manslaughter and robbery. Brown, who had fired the shotgun, was charged with first-degree murder. The charges against Jones, who was not involved in the robbery itself, were later dropped. The already famous crime also became notable for being extensively mishandled. The move to trial was extremely slow as the men sat in jail for years being denied bail, but not being brought to trial. The case was marred by errors by police and prosecutors, but it was mainly lengthened by defense lawyers who were later accused of unprofessional conduct. While the new defense team argued the charges should be thrown out due to the long delay, the motion was rejected. By the time it came to trial, 40,000 pages of files related to the case had accumulated. The trials finally got underway in May 1999, with Brown now acting as his own defense counsel. The trial itself became one of Canada's longest trial, with Brown extensively cross-examining each witness, often up for 2 days. Allegations of racism and discrimination, where we heard that one before, were leveled from the very beginning. One of the lawyers, there were dozens hired, fired, and removed, likened the preferred indictment to the modern-day equivalent of a lynching. Moreover, in a letter written in 1995 to Ian Scott, then Chief Counsel for Special Investigations at the Crown Law Office, lawyers for the accused alleged that this case has drawn a tremendous amount of publicity, not because of the nature of the crime itself, but because the defendants are all black. Ms. Lemonos, the victim, was white, and the incident occurred in an upper middle-class restaurant frequented primarily by white people. What I didn't mention is she was not the only victim, Mr. Chair, in that restaurant. There were probably another dozen, if not 24, victims who had to experience this random shooting designed to wound, maim, disfigure, and in this particular case, to this victim, ending her life. In a scathing 60-page summary ruling on the case by Mr. Justice Brian Trafford, puts the police and the justice system in an unenviable light. The selective use of leg irons, belly chains, and handcuffs on the 3 suspects displayed cultural insensitivity towards black people, stated Judge Trafford. He also found that to this day, Toronto police have never comprehensively investigated allegations of abuse. Activists angry at the use of shackles have brought up the specter of the slave trade. They have pointed out that Paul Bernardo was never shackled in court. Verdict. The case continued to attract widespread public interest. On the day after the trial closed, on December 6, 1999, the Globe and Mail published an unprecedented 6-page section devoted to the murder and trial. The verdict was finally released on December the 11th. Brown and Francis were found guilty and Grant was acquitted. Brown was given a life sentence with no chance of parole for 25 years. Francis was given 15 years and 7 were knocked off for the years in jail during the trial. He was thus eligible for parole only 3 years later, but his 2002 application was rejected. He was released on parole in 2005. On February 24, 2008, he was found in possession of 33 grams of crack cocaine, and in May 2008, sentenced to 7.5 months in jail for several drug-related offenses. And I will be talking about, eventually, the drug component to Bill C-5, but certainly not in relation to this particular clause. Grant was deported from Canada to his native Jamaica, where he was shot to death on October 29, 2007. So that's one example, Mr. Chair. I have another. Does anyone remember the Boxing Day shooting, downtown Toronto, Yonge Street in Dundas, one of the most heavily populated shopping areas in all of Canada? That was known as the Jane Creba case. That particular shooting was a Canadian gang-related shooting, again attracting Section 244 considerations, which occurred on December 26, 2005 on Toronto's Yonge Street, resulting in the death of 15-year-old student Jane Creba, who had the misfortune of taking her Christmas money as she got from her parents and relatives, and had the misfortune of traveling down the street because she wanted to attend, at that point, was a record store. Toronto actually had record stores on Yonge Street in 2005. She never made it to the record store. She never used her Christmas money. She wasn't the only victim, Mr. Chair. 6 other bystanders, 4 men and 2 women, were wounded. And again, and I mean no disrespect to Mr. Morris, I think he's a fine gentleman and a fine parliamentarian. I have a lot of respect for him. It's the position of your party that I'm criticizing, sir, not yourself. This particular incident and the amendment, really there is a disconnect as to what we're trying to do here. We're not trying to make it easier and make it softer for the type of individuals who decided on Boxing Day in one of the busiest areas in the country to wildly shoot. And Jane Creba, I might add, was not the intended victim. There was another gang-related person in her vicinity. But let's face it, and let's be honest, apart from the example I gave you in Brantford of the 2 young men outside the variety store who were good shooters, the vast majority of gang-related activity and the use of firearms, mostly, if not all, illegal firearms, not the long firearms, the long rifles. You don't take a long firearm into a variety store and say, hey, I want to rob you. You want to conceal that weapon. You can't conceal a long-armed firearm. But in this case, my point is these criminals are not equipped. They don't have the training. They're not expert marksmen, if that's the phrase, or marks people. They just shoot wildly, hoping that one bullet perhaps may hit the intended target. It didn't in this case. It killed 15-year-old Jane Creba. 6 other bystanders, 4 men, 2 women were wounded. The story generated national news coverage in Canada and influenced the then underway 2006 federal election campaign on the issues of gun crime and street violence. Indulgence, please. Police arrested 2 men on several gun charges at Castle Frank subway station within an hour after the shooting. Andre Thompson, 20, he was on probation at the time, and Jorel Simpson Rowe, 17. Thompson had been released just before Christmas from Maplehurst Prison near Milton, where he had served 30 days for his role in a convenience store robbery. He declined a bail hearing for his current charges. Police believe as many as 10 to 15 people were involved in the shooting and that more than one gun was fired. 20 Toronto police detectives were assigned to Project Green Apple. It was named Project Green Apple because that was Jane's favorite food, to work on the case. On June 13, 2006, Toronto police conducted multiple raids at 14 locations throughout Toronto in the early morning, arresting 6 men and 2 teenagers. Charges laid against them included manslaughter, second-degree murder, and attempted murder relating to the 6 other bystanders. All arrested are members of 2 different street gangs. In October 2007, a young man who was rounded up by the initial arrests, Eric Boateng, was shot dead in a seemingly unconnected incident. Boateng was not charged with the shooting, but was later charged with cocaine trafficking. It's too bad that I guess that didn't happen in 2022 because he might receive a conditional sentence. Again, I'll speak to that aspect of Bill C-5 in due course. As of December 2007, 10 people have been charged with murder or manslaughter in the case, 3 of whom are youths. Those charged with second-degree murder include Tayshawn Barnett and Louis Woodcock, both 19, Jeremiah Valentine, 24, and Jarrell Simpson Rowe, who was 17 at the time of the shootings. One of the teenagers who was arrested in June and charged with manslaughter was exonerated on October 25, 2007, after the preliminary hearing. The teenager charged with murder was committed to trial. On December 7, 2008, Jarrell Simpson Rowe, previously known as JSR, because the Youth Criminal Justice Act forbids disclosure of identities of minors, was convicted by a jury of murder in the second degree. In April 2009, he was sentenced as an adult to life in prison with no chance of parole for 7 years. In November 2009, manslaughter charges against 4 individuals involved in the incident were dropped because the prosecutors felt there were no reasonable prospects for conviction. And on that point, I really stress the whole concept of prosecutorial discretion, Mr. Chair. But in addition to that basic tenet, we are also bound by 2 rules. Every prosecutor who gets a case to prosecute has to ask themselves 2 questions. Question number 1, is there a public interest in continuing the prosecution? That's generally a very low threshold analysis, Mr. Chair. And when you take a look at the number of ways people can commit criminal offenses, you just got to take a look at the size of the criminal code, which represents all the laws in this country. You can well imagine that there are extremely less serious charges, all the way to the most serious of charges, which includes murder. And quite often, I had to exercise my discretion by answering the question, is there a public interest in this prosecution? By coming to the conclusion, Mr. Chair, that perhaps capturing the language of the Liberal government, that there are situations where good people make some pretty bad decisions on a particular bad day. And quite often, by reading the entire Crown brief, I was able to determine where in the equation of spending all of this public resource money and the time, my time and the judge's time and the police time to monitor and provide security, and the clerks of the court and the other staff processing the paperwork, where is there an interest in continuing that particular prosecution? It didn't happen a lot, Mr. Chair, but I can tell you I can probably count maybe on both hands over 18 years where I answered that question in the affirmative. And again, had the backing of Mr. Naqvi as my ultimate boss at the time, as the Attorney General, that I could justify the decision to pull that case, withdraw that case from the criminal prosecution stream. So that's the first question you ask yourself as a prosecutor. Second question, which really is an important question because you have to ask this question numerous times throughout the lifespan of a criminal charge. And as I've described to the committee, some cases can get wrapped up in very short order, 2 or 3 months. Quite others, with the advent of charter litigation and as you've heard, as I read out the story of accused firing and rehiring and firing and rehiring defense counsel, sometimes cases can drag on months, if not years. But through that entire process, at each pivotal point in that particular prosecution, we as prosecutors have to ask ourselves, is there a reasonable prospect of a conviction? I ask that question the first day I get a Crown brief from the likes of my colleague, Mr. Morrison, when he was actively engaged in law enforcement, to the time I receive further disclosure from Mr. Morrison and other like-minded law enforcement personnel, to the point where I'm now engaging in discussions with defense counsel, or perhaps engaging in thoughtful, productive discussions with my colleagues. Because although we all have law degrees and we all have the same sort of legal training, as far as working within the criminal justice field, particularly with the Attorney General, they afforded us with numerous opportunities to engage in continuing legal education. Some people retain more issues than others. So quite often on major cases, I would either be paired up with another colleague or we would just share ideas and ask. I see this as a case where there is a prospect, it's a reasonable prospect of a conviction. A colleague may not see it that way. So again, the Crown Prosecution Service is constantly evaluating and re-evaluating and welcoming and receiving further information from law enforcement, receiving further information from defense counsel, often charged with the responsibility of putting the very best case forward for his or her client, and particularly within the context of an Indigenous offender or a marginalized offender, to talk about the upbringing of that particular offender in the hopes that perhaps I can look at either abandoning it in its entirety, that prosecution, which was a very bitter pill for me to digest and quite frankly was contrary to Ontario Crown policy, because our policy was very clear that if there was a reasonable prospect of a conviction, every firearm offense had to be prosecuted, and only and when if you ever got permission from your Crown manager could you deviate from that policy. But Mr. Chair, it did happen. And it happened to me on a couple of occasions with Indigenous offenders. As I told you, Brantford has a Gladue court, or an Indigenous Peoples Court. And I can remember the case very well. It involved an individual who had a significant criminal record, not only in Canada, but also the United States, who had all of the Gladue factors that you can think of: unstable family, no employment, lack of education, food insecurity, ties to the residential school system. Every single marker was checked off. But he found himself, Mr. Chair, in possession of a loaded firearm. He didn't discharge it, but it was captured by the language in Bill C-5. It attracted a mandatory minimum penalty. But in that particular case, we engaged in a deep discussion, not only about the offense, but about the offender. And how the Indigenous Peoples Court, and I think how Gladue courts operate, and we certainly don't have enough Gladue courts in this country. Quite frankly, I think the government should be looking at mandating that. I know they'll have to work with the provinces in terms of rolling that out with various ministries, but there are advantages to these offenders, Mr. Chair, that Bill C-5 on its own only scratches the surface. So in this particular case, I heard his story. It was one of those opportunities that you really never get as a Crown prosecutor. And in fact, I had prosecuted that same individual for a different offense probably 2 or 3 years prior to that. I didn't remember him. He certainly remembered me. And how the Indigenous Peoples Court operated is you wouldn't force the offender to be arraigned. And arraigned means where the charge is read out and they have to make an election. Do you plead guilty or not guilty? The presumption of anyone who entered into the Indigenous Peoples Court was that there was a willingness and an acceptance of responsibility, that they had to ultimately plead guilty, but that we would thoroughly examine the circumstances of the offense and the offender to determine the best sentencing outcome for that particular offender. So in this case, he wasn't arraigned. We're all in a circle because the whole concept of Indigenous Peoples Court is to break down barriers. We heard from witnesses in this committee that there is a lack of trust that Indigenous peoples have with the criminal justice system. They have their great law, we have our criminal code. And the two systems could not be more diametrically opposed to each other because they are. So there is an inherent mistrust. The two pioneers of the Indigenous Peoples Court in the Brantford jurisdiction was Justice Colette Good, a former Crown attorney in Brantford, and another judge, and the name is escaping me right now, it'll come to me, who is also Indigenous. And the whole concept was born from an idea to deliver justice differently to our Indigenous offenders, because we knew, and this Indigenous Peoples Court, Mr. Chair, has been operating for over 10 years in the Brantford jurisdiction. We knew a decade ago, if not longer, that the over-incarceration issue was an issue. And the judiciary in Brantford took immediate steps to address that. So part of the composition of the Indigenous Peoples Court is that the judges would not appear inside that courtroom with their gown. They would take the black gown off, they would take their red sash off, they would take their tabs off, the judicial tabs, and they would appear in business attire. We're all familiar with the composition of a criminal court. You walk in, you'll see rows of seats, you'll see we call it the bar, the legal bar. You're only entitled to cross that bar, and the bar separates lawyers and staff from the public. So we have the bar, we have an opening, we have chairs for defense and Crown Counsel, tables, we have the court clerk, court reporter, and then we have an upper area known as the judicial dais. And that's where our judges sit. And Gary knows that because he's a lawyer. Oh, okay, well, I'm glad you're enjoying this. It's good stuff, isn't it? Yeah. So, and that dais, Mr. Chair, is probably, I don't know, 10 feet above the main floor. But it creates a psychological barrier. It creates a barrier that the judges of this particular court wanted to break down. So they've insisted that when they come in the court, they move directly into a circle. And the circle was designed being respectful and mindful of indigenous traditions, that when important decisions were being made with elders and family members and outside individuals, that you wanted to have a circle so that there was an understanding and there was a chain of communication that would not be broken by having various members displaced within the courtroom. We also had the benefit of an eagle feather. And an eagle feather is very, very important for Indigenous men and women and children because it represents their connection to Mother Earth, and it binds their conscience and it allows them to speak freely on issue without prejudice, without fear, without criticism. And the only way that these Indigenous circles work is that you break down the traditional norms of a traditional criminal setting. So that we would start these circles with an Indigenous knowledge keeper. On the Six Nations of the Grand River, there was probably a half dozen Indigenous knowledge keepers that would regularly attend Indigenous Peoples Court, and we would run these courts, Mr. Chair, roughly twice, maybe 3 times a month. And the Indigenous knowledge keepers would attend, and they would open the ceremony by speaking in their Indigenous tongue, and they would then translate it to the non-Indigenous members of the circle. And quite often it was along the lines of opening up your soul, opening up your mind, opening up your ears to accept the information that you're about to receive, to sort of disbandon your traditional legal role, to be part of the circle, to have a clarity of understanding. And after they would give the opening, they would then start by passing the eagle feather in a counterclockwise fashion. I don't know the significance of that, but there is a significance. And you would only be allowed to speak when it was your turn and you had the eagle feather in your hand. So that then we would do various rounds, Mr. Chair. And the first round was simply to introduce yourself to the offender, and the offender quite often would have family there. Sometimes they would have nobody there. We would also have representatives of social agencies that deal with Indigenous offenders in the Brantford criminal justice system. When it came time for me to hold on to the feather in round number 1, I would identify myself. I would indicate what my professional role is. And I would inform the offender that this was a non-judgmental format, that I am not here to criticize, I am here to listen, I am here to learn, and I want to be in a position, Mr. Chair, where I'm armed with all the necessary tools to discharge my responsibility and exercise discretion if it was appropriate. So I would explain that to the offender.
It's Coke. It's a Coke.
So it's okay. It's okay. In this particular case, do you want me to start over?
Start over.
in this particular first round, in this case that I'm referencing, I just sort of gave you an overview of the Indigenous Peoples Court. Now I'll get more specific to Ms. Diab. Okay? No problem. I try to be helpful. Okay? So in this particular case, this offender that I referenced.
I think there's a point of order. No, sorry.
Okay. This particular offender, who had both a criminal and American record, facing a serious charge, says to me, Mr. Brock, you don't remember me, do you? And I said, no. Should I? He said, yes, you prosecuted me. You didn't give a damn about me 2 years ago. His exact words, you didn't give a damn about me 2 years ago. Why should I listen to you now? Fair comment. 9 times out of 10, if not 99% of the time, as a prosecutor, they have a lawyer. And that lawyer is their representative. There are rules of conduct, Mr. Chair, that you are aware of as being a lawyer, as mandated by the province. Not by the province, sorry, by the Law Society of your particular province. And as Crown Counsel, I couldn't just walk up to an offender and force him to engage in conversation. And he remembered that. So his point was, you didn't care when you didn't have the ability to question me or talk to me, and maybe because he didn't know that I had ethical obligations on my part where I could not do that. And quite frankly, to any of the lawyers on this committee who's had any sort of experience in a busy criminal court, you know you don't have that opportunity. In a given day, Mr. Chair, I was prosecuting anywhere from 30 to 40 cases. You don't have an opportunity to get to know your offender. So I explained to him, I said, fair comment, but this format is vastly different. So I explained why it was different. Second round. For the first time in my life, I'm now talking directly to the offender and pointing at him and saying, what the hell were you thinking? What caused you on that particular day to pick up that loaded weapon? What were the circumstances? Again, never ever having an opportunity like that as a Crown prosecutor, with the exception of a trial format, and if he wished an opportunity to testify, which he's not constitutionally required to do that, at all times, it's the Crown Attorney's onus and burden to prove a case against an individual beyond a reasonable doubt. Until there is a finding by a judge, Mr. Chair, accused persons have the luxury of a presumption of innocence. They're not compelled to provide a defense. They don't have to give a defense. They don't have to disprove anything. They can sit in the weeds and determine whether or not Mr. Brock, the Crown, or any other Crown has proven all the essential elements of the offense. But this was different, and he recognized the difference. And slowly, like peeling layer of an onion, layer by layer by layer, with my questions and the judge asking similar questions, and the offender's own lawyer asking similar questions, and the knowledge keeper trying to draw in, why are you doing this as a proud member of an Indigenous clan? Why are you engaging in this type of criminal behavior? And the family members who are there. These were very emotional events, Mr. Chair. Numerous times my eyes swelled up because you really got to the heart of the matter that you would never get in a trial, that you would never get by simply reading a Gladue report, that you would never get by simply listening to defense counsel talk about the circumstances of the client's background. So after you had that sort of awakening, I call it, and a challenging of why they found themselves in conflict with the law, then you went to the next round and you looked at ways that the offender wishes to learn from this particular exercise. And again, a foreign concept to the traditional criminal justice format. If I'm successful as a prosecutor in securing a conviction after trial or presenting a guilty plea, you don't question why. You don't question steps that they're going to take for their own rehabilitation. And while I know that rehabilitation is an important sentencing feature in any given case, in a traditional criminal format system, sometimes it doesn't play as much as a factor as the other sentencing principles, particularly in these areas, as I've referenced in earlier interventions tonight, several hours ago, where I talked about how judges repeatedly, not only in Canada, because I've done case law research on other larger cases across this country, have repeatedly cried out for sentencing principles that apply denunciatory sentences for gun offenses and send a very strong deterrent message to the offender and to the community that you engage in activities like this, you will expect to receive a jail sentence. Now, going full circle back to the Indigenous circle. So I was able to listen to what the plan was that this offender had for his life, and he was very candid. I think he was a grandfather many times over. I think he was in his 60s at this point. He suffered just horrible, horrible examples of abuse, physical and sexual, outside of the criminal justice system and inside as an offender. Predominantly much worse in the United States because he found himself in a carjacking situation in Buffalo as a young offender. I think he said he was 14 or 15 at the time, with 2 adult friends who were 18. And he was tried as an adult. He was sentenced as an adult. Did some hard time. I forget the institution that he was at. But as a young boy, you can only well imagine the horrors that he experienced in an adult male population. And he had no problems recounting that and sharing that terrible chapter in his life. But he had enough. He had enough, and if I had $1, Mr. Chair, for every offender who said, "This time it's going to be different, Judge. I've learned my lesson, Judge. You're never going to see me here again, Judge." Okay, I'd probably long be retired, Mr. Chair, because it's hollow words. It's much the same sort of insincere rhetoric that I used to hear daily in bail court, where they would promise the justice of the peace, "Oh, throw on as many conditions as you want. I'll comply with everything. I'll comply with house arrest. I'll stay away from the alcohol. I'll stay away from the drugs. I won't harass my girlfriend, even though I've done it 10 times over." They'll promise the sun, the moon, the stars just to secure the release, but it's hollow. It's a hollow promise. And I experienced that in the criminal justice field as well, but different in the Indigenous Peoples Court. So I listened to him, and I said, I'm not going to mention the offender's name, out of respect. I said to him, "You'll have to forgive me if I don't believe you. You'll have to forgive me if I have my doubt." And I explained why I had my doubt. But I said, "You appear to be sincere, so I'm going to give you a challenge. You talked about upgrading your education. You talked about getting some counseling for your addictions. I think he was addicted to crystal meth or a harder drug. You talked about securing a job. You talked about being a role model to your grandchildren. You recognize to be a role model, you're going to have some stable housing. So he made a commitment to that. So this particular case, Mr. Chair, probably lasted the better part of 2 years. Ordinarily, someone accepting responsibility to something like that would have been in and out of the criminal justice system in 2 or 3 months, would have been serving a sentence in some institution long before this particular case ended. But he did everything that he set out that he would do. And he not only showed me certificates of attendance, he showed me certificates of putting 110% effort into everything he said he was going to do. He came armed with character reference letters from the institution and the organizations he was involved in. He found himself a job. He was earning a regular paycheck. He had turned a significant page. And it came to the point, Mr. Chair, I had to ask myself, I've got all this discretion. I've now seen an offender who was sincere in everything he said he wanted to do to change his life. Do I believe that there is a more than a reasonable prospect that I will never see him again in the criminal justice system? I concluded that that was the case. And through my discussion with my Crown manager and other colleagues, we were able to craft a sentence that still held the offender responsible, but prevented the traditional brick and mortar institution. So to all the members of this committee who feel that the Bill C-5 that we are currently debating is the answer to all of these issues, I've given you an example of steps that Crown prosecutors are doing, who are doing daily, and take the job very seriously. There are other ways to address the over-incarceration issue without compromising community safety. That was the example I wanted to share with you. I've often asked myself, when and where should I raise this issue? And I think now that it's on my mind right now, I don't want to lose the train of thought. But we've heard it. We've heard it numerous times in this committee, Mr. Chair. We've heard it numerous times, not only from witnesses, we've heard it from committee members. We've heard it from the Attorney General. We've heard it from all other senior ministers. We've heard it from the backbench. We've heard it from the Greens. We've heard it from Ms. May. We've heard it from Mr. Morris today, that we should trust our judges. The judges know best. The judges need to have this discretion in their hands to do their job. To that I say, as a proud member of the Ontario Bar, a proud member of 30-plus years, and when I say what I'm about to say, I mean absolutely no disrespect to the judiciary, and I appeared in front of many judges in my lifetime, Mr. Chair. They too, just like Crown attorneys, are not walking robots. They do not all think the same. They do not all pronounce judgments in much the same way. Hence, we've got appellate courts, depending on the charge, depending on Crown election, to proceed summarily. Sometimes the appellate route is to the Superior Court of Justice or the Court of Queen's Bench for my Western colleagues. or the various provincial court of appeals, or ultimately the Supreme Court of Canada. Judges, folks, do not think the same. They do not apply the law equally in the same respect. There are judges who have acquired reputations, soft, hard, in between, all in between. And I'll give you another example. There was one particular judge in the lower court in Brantford. Again, I'm not going to repeat her name out of respect. I know you'd like me to, but I simply can't. I can't, Gary. I can't. So, extremely frustrating to Crown attorneys. Very, very frustrating to us, because it appeared as if, and it was a female justice, that she just had a different perception on criminal justice and always placed the principles of rehabilitation paramount. And would mention, well, this is an offense that attracts. Only women would do that. Well, not necessarily. I get some great female judge examples I can share with you, Ms. Diab, and I will. Afterwards. Really, really good examples. But I think you're going to like this example, okay? Because it goes to the narrative and it goes to Mr. Morris's comment that we should trust our judges. Is there a point of order? Oh, okay. Okay. Teach him what not to do?
Je dirais que si ça fonctionne comme à la Chambre, Monsieur le Président, je vous prierai de regarder l'horloge. Vous allez constater qu'il y a un consentement unanime à l'effet qu'il est à cette heure pour arrêter, 9h30. Non?
I received no translation of what Monsieur Fortin. It's a couple minutes ahead, but if this is a good time, as ever, we will.
Point of
as
order.
Court or
Point of order.
resources. Somebody said point of order. Yes.
I would like to share three brief facts with respect to Amendment PV 17, if that.
I can give you 2 minutes, if that would be suffice. Then we
appreciate
have to
that.
suspend. It's 9:28.
So with respect to Ms. May's PV 17, Mr. Brock brought up the NER decision. Would like to just share for the committee that in the NER decision, the Supreme Court of Canada summarized with respect to mandatory minimum penalties, their quote is, empirical evidence suggests that mandatory minimum sentences do not, in fact, deter crime. Secondly, Mr. Brock brought up his concern with the government not moving forward on the Truth and Reconciliation Commission's calls to action. I'll just share for the committee. Call to action number 32 from the Truth and Reconciliation Commission is the following. We call upon the federal government to amend the criminal code to allow trial judges, upon giving reasons, to depart from mandatory minimum sentences and restrictions on the use of conditional sentences. I believe Mr. Brock earlier was encouraging this committee to follow through on the calls to action of the TRC. Finally, there was a question with respect to who else Greens are following with respect to amendments like PV 17. I'll just note that the Black Legal Association Centre, the Canadian Association of Elizabeth Fry Societies, and the Women's Legal Education and Action Fund have all also called for the removal of mandatory minimum penalties. Thank you, Mr. Chair, for the opportunity.
So we can dispose of it?
We have about 30 seconds.
If there's no objection, we can dispose of it tonight. We're willing to support Mr. Brock.
To do a vote on the.
I still was going to speak to this motion as well, so.
Since we have more speakers to this, Mr. Nansangari, we are going to End the meeting and
Let's hear
adjourn.
it.
Meeting's over.
On Friday.
So,